Yes, Mr. Rawat.
Thank you, Commissioner. This morning, Dr. Daniel Orlando-Smith has returned to give further evidence. Just for the transcript, can I just record that there are no legal representatives of any participants attending remotely. Dr. Smith, can I first of all begin by thanking you for coming back to give some additional assistance to the Commissioner today. All I need to do is just to ask you just to try and keep your voice up as much as you can, which is something I do with every witness. But hopefully I will try and keep the questions as short as possible, because there are specific matters on which the Commissioner would welcome your further assistance. And these arise from evidence that has been provided by the internal auditor over the course of the last couple of days. To assist you, I hope the Commission wrote to you to confirm which reports from the internal auditor we might need to ask you questions about. And I hope you were provided with copies of those reports, I understand. Thank you. The first of those, if I could ask you to, if you've got it, it's the report on belonger status. Commissioner, it's in part 1 at page 851, open brackets 1, close brackets.
This is the court reporter. Is it okay for Dr. Orlando to remove his mask?
Dr. Smith, the stenographer wonders whether you would like to move your mask, because it'll make the transcription easier. But if you do not want to remove your mask, can you make sure that your answers are clear enough for the stenographer to pick up?
I will try.
Yes, and Mr. Kazdan, if you can let us know if anything is unclear, we'll make sure that the answers are clear before we proceed. Is that all right, Dr. Smith? But I'm happy for you to retain your mask. We just need to make sure that your answers are recorded. Thank you very much.
Thank you.
Dr. Smith, can I confirm that what you've got open in front of you is an Internal Audit Department report on the Immigration Board belonger application process of June 2012?
That is correct.
Thank you. Have you had an opportunity to read that report?
I have.
Thank you. If just for the transcript, just so that we can give it some context, if you turn, Dr. Smith, to paragraph 5.1, which is on page 851, open brackets 5, close brackets.
Audit scope?
Yes. What it explains is that the audit focused on belonger status issued between 2009 to 2011. And if you go through to the next page, please. Just draw your attention to just under objective 1. The report explained that the process can be divided into 3 phases. The first phase is the application phase, when an application is submitted to the Department of Immigration. The second phase is the consideration and recommendation phase, and that's when the Immigration Board would review the application and make a recommendation to Cabinet. And the third phase was the approval or denial phase, where Cabinet either accepts or rejects the recommendation. If you turn back, Dr. Smith, to the executive summary, which is on page 851, open brackets 3, close brackets. And you look at paragraph 1.1.5 of the executive summary. It explains that Cabinet approved 224 persons who were not considered by the board and for whom no recommendation was submitted. And what's said is that Cabinet's approval of status in this manner renders the purpose, operations and functioning of the board null and void, as one of the reasons for which they were appointed and engaged is undermined and in some instances ignored. What the audit found was that the names were not even on a Cabinet paper, but rather they were added at Cabinet level based on personal representations from members. Now, that gives you the background, Dr. Smith. What I should also add was that the internal auditor in her oral evidence confirmed that, and if you look at page 10, if you look at page 85110, I can explain it this way. You will see that there's a table there, table 2, that looks at the years 2009, 2010, and 2011, and the 224 applications happened in 2011. The internal auditor confirmed that this finding related to the Cabinet that was in existence before the 2011 election. So that wasn't your Cabinet, was it, Dr. Smith?
No, it was not.
You became Premier and Minister of Finance in November 2011.
That is correct. Yeah.
You've confirmed that that's correct. Now, the report that we are looking at is dated June 2012. So that is after you assumed office. And so my first question to you is whether this report was brought to your attention when you became Premier.
I do not recall seeing this report. I know, based on reading the document, that my permanent secretary made some comments on the report.
So is that a surprise? Is it something that you would have expected to have been brought to your attention as Premier?
Usually when the auditor, internal or external audit, makes a report, they send a draft and it's commented on by the permanent secretaries in the particular ministry. Then it goes back to the chief auditor, then it goes forward, comes forward, at which point I would have seen it. The reality is that at that time when we got elected in 2011, end of 2011, it was quite a chaotic period in the ministry. I had no permanent secretary for some time. And then I had gotten a permanent secretary who was there for a short period of time until eventually Mr. Penn came by. So it was quite some time before we got settled down. And this did not come to my attention.
And when you're referring, Dr. Smith, to not having a permanent secretary, is that a permanent secretary in the Premier's office?
In the Premier's office, yes.
And at that time, 2011, 2012, was immigration did that fall under the remit of the Premier's office?
That is correct, yes.
I suppose the concern that's raised by the internal auditor is that, in effect, at Cabinet level, an additional 224 people are introduced for the purpose of considering whether they should have belonger status or not. Accept that your evidence is you didn't see the report, but were you made aware of whether any steps were being taken to address issues around belonger immigration?
When we got into office, we took the process quite seriously about giving status, whether it's residence or belonger status. And we compiled the persons who had made submissions, forward them to the Board of Immigration, who made their comments, and then send them along to the to the Cabinet.
So were you told that there were 224 people that hadn't gone through that process, but had been at least approved for belonger status?
I don't recall being told that.
A second point that the audit raises was a disconnect between law and policy. If you look at page 19, so 851 open brackets 19 close brackets, this is an appendix to the report, and it's where the Internal Audit Department has set out the law and the policy. And if you look under section 16.3, and this is of the Immigration and Passport Ordinance, what that prescribes is that a person could apply, would have to be ordinarily resident in the territory for not less than 10 years immediately prior to the application for belonger status. But if you go over to 2 pages to 21, we see there that a policy had been approved in 2006, the effect of which was that you would have had to have lived continuously in the territory for over 20 years to qualify, and that the number of applications would be limited to 25. And if you, in the same paper, if you go over to the next page, what the Executive Council had then recommended was that steps be taken to increase the qualifying period for belonger status to 25 years. And so what the audit showed was that although in law, someone could make an application after 10 years, the Immigration Board was applying the policy on the basis that you had to have 25 years. And that was the disconnect that the auditor identified. Now, at that time, in June 2012, were you aware that there was a difference between law and policy?
There's a difference, yes. But if you go back to page 85119.
85119.
It says, a person may be granted a certificate referred to if he has been ordinarily resident in the territory for a period of not less than 10 years, immediately prior to his application. That gives the cabinet the latitude to make policy. It says not less there, so it could be 12, 11, 13.
I see. So from your perspective as Premier, that allowed cabinet to have more than 10 years as a requirement.
Correct.
I see. Because I think the internal auditor identified it as that's the threshold. If you reach 10 years, you can apply, and if you satisfy all other requirements, you should get it. But your view as Premier was that there was latitude for cabinet to set a higher threshold if necessary.
Could you go back to 85121?
Yes, please. So that's the Executive Council's policy of July 20th, 2006.
And the first in 8 says, in the case of persons, sorry, there's another section. Oh yes, C.
Yes, it's C that
once a backlog of those identified as B have been cleared, the board should make recommendations as applicants reach the 20th anniversary of their arrival in the territory after the normal screening process. Now, what it says there is that that's when the board should make a decision on those applicants. It did not say that it could not apply before. It says that's when the board should make a decision.
I see. So your understanding of how the law and policy connected together was firstly that there was nothing to stop cabinet setting a higher threshold than 10 years as a policy.
The policy did not say that it could not apply from 10 years. The policy says that the board would make a recommendation. The applicants reach the 20th anniversary of the arrival in the territory.
So an applicant could apply at the 10-year mark,
Yes.
but under the policy, it would only be once they've reached 20 years that the board could make a recommendation.
That's correct.
I think that what the auditor picked up that the board was doing was actually applying 25 years based on what was then the Executive Council had asked they'd suggested the Attorney General amend the Act to. But your understanding was what the board should have been doing under the policy is taking 20 years as a threshold.
Yeah. Because I think the 5 years, I think most likely included 5 years before residency.
I see. Whether you have a 20-year residency qualification or a 25-year residency, what's the rationale? What was the rationale in having that threshold when your law said someone could apply after 10 years?
The rationale of having a threshold of granting, of the board making the determination for them to be granted. Giving of belonging status is a significant thing in most countries. Our citizens, as you know, as in UK and America, so it's a very significant thing. And we have to be, our country has to be careful about how they go about doing this. We looked at several different countries. We looked at America, for example. It takes at least 10 years or more before this can happen, much more. My son took probably over 15 years. We looked at a country like Monaco, and only 3 people were given belonging status or citizenship in any year, and that was by the Crown Prince. So there were various ways in which countries decided when the time was right to give citizenship. The other point is that it is important when you are given residence or citizenship, belongingship, to look at numbers, because it is important that people who are accepted and adopted into the country have time to assimilate into the country. If this does not happen, it causes conflict between the persons who were there before and those who come afterwards. So those are factors that you took into consideration when making this decision.
If you look, please, Dr. Smith, at page 851, open brackets 31, close brackets. You should be at the management response. Do you have that?
Yes, I have that.
Thank you. And if you, this is obviously a response that's coming from the permanent secretary and the desk officer for immigration. So it's within the Premier's office, but not coming directly from yourself as Premier. What is recorded, one recommendation was that steps should be taken so that the policy that we've just been looking at and the Act which set the threshold at 10 years or not less than 10 years should be reconciled so that they were in sync, and as the internal auditor says, there's no confusion in administering the guidelines. The response to that was to agree and that action would be required to make policy law, and that the completion date was given as March 2015. Now, as we'll see in a moment, nothing appears to have been done. Can you remember whether steps were taken to try and bring the policy and the law in sync?
This was a response by members of the administration who had some responsibility as far as immigration is concerned. The cabinet of the Virgin Islands at the time develop the policy based on the factors I explained a little while ago. And there's no, in my mind, there's no need and no reason that a policy and law cannot exist. In fact, it always exists.
So from your perspective as Premier at the time, you didn't see this disconnect that's been identified here between law and policy. And for the transcript, Dr. Smith said no to that.
Yes.
If I ask just, I'll take you for completeness, Dr. Smith, to the follow-up report that the internal auditor did, and you'll find that in a second bundle, but I think you have your own copy. So we're in part 2, Commissioner, at page 1737. Actually, 1735 is the front page. This, Dr. Smith, is the follow-up audit that the internal auditor did in January 2014. So obviously that's still during the period in which you are still Premier and Minister of Finance.
Correct.
And if you go just to the first page, 1736. Six, just the next page over. You'll see it's the table of contents. And it just tells us that in terms of the recommendations that the internal auditor had made, the internal audit department made 9 recommendations. 1 was not agreed, 2 were partially implemented, and the remainder had not been implemented. But if you look at 1737, which is a recommendation, the recommendation we just looked at in terms of making amendments to the actual recommendation we looked at is at 1738, but the point that had been made by the internal auditor was this recommendation to bring law and policy more closely aligned. If we look at 1737, what the follow-up audit noted was that the Premier's office has indicated that work has commenced on amending the Immigration and Passport Ordinance CAP in order to bring both the ordinance and policy into alignment. To date, there has been no revision or change to the ordinance or policy. The conflicting policy document continues to be used as the criteria for eligibility for belonger status. As a result, the issue continues whether individuals desirous of acquiring status are deprived being considered because the policy stipulates a 25-year qualifying period, whilst the ordinance states 10 years. The use of such criteria continues to be illegal. Now, we're now in January 2014. We've moved on some 18 months or so. When this follow-up audit was carried out and the internal audit department raised the issue again, was that brought to your attention at that point?
No, this was a decision, a recommendation by members of the team. This did not come to cabinet for any confirmation.
The reason I ask whether it's raised with you is twofold. Firstly, that this is happening in the Department of Immigration, and that's sat under the Premier's office, and you were obviously the Premier. But secondly, it goes back to the issue that in 2011, a cabinet had given 224 people belonger status without their having to go through the proper process. And so that's one aspect of this audit process that's been picked up. And the second aspect is the lack of clarity between policy and law. So taking it back to the question, it's not necessarily about something going to cabinet, but what you have is in your department, the internal auditor saying there's still a mismatch here, it's illegal. Did no public officer or a permanent secretary come to you and say this is an issue that might need to be resolved?
No. Can I go back a step for information?
Of course.
When my government got into office in, what year was that now?
You were November 2011.
2011. No, before this. Recall the process for giving status, whether it's belonging status or resident status. There was quite a backlog. This goes back to 2003, actually. There was quite a backlog. I call it a backlog, but there are large numbers, over 200 people, applicants, who had not been considered, both for belonging status and for resident status. Because apparently, not many people were being considered before that time. When we got into office, he said, and this goes back for quite a few years. When we got into office in 2003, he said, let us do something about this and let us sort these people out. And so we set about, on a regular basis, in fact, I think we were supposed to be doing 50 every, batches of 50, until we were able to clear that people who were there before waiting. And during that time, many people, by the time that was finished and we had our policy, many people would have been 20 years and ready for belongership at that time. So it was a systematic way of dealing with the fact that this had not been dealt with before, and having a regular approach to having either belongership or residence sorted out through the Board of Immigration. And I think I explained to you our consideration about belonging status.
According to this report, the internal auditor and your own permanent secretary considered that there was a disconnect between the law and policy, and that the policy was unlawful. That's what they both considered to be the case, and that's why the permanent secretary was working upon a change in the law to bring it in line with the policy. But you say you didn't know anything about that.
No, and they may have been working on it together, but I have not seen any review by the Attorney General when they were considering that, who is the final arbiter when it comes to law in the British Virgin Islands. So there's no comment from the Attorney General, and certainly did not come to Cabinet.
No, I understand that. But you didn't know that your permanent secretary is working on a revision of the law to bring what he or she considered the law and the policy into alignment.
When matters come before the ministry, the permanent secretary and those who work with him will normally work on the matters and come to some conclusion that they think is appropriate before bringing it to the Premier, who then takes it to Cabinet for a decision.
Yes, thank you.
If you go to 1747, please.
I'm not sure which one that is.
It should be in the same document.
Slight difference in the numbering.
I see. If you want to use the document's internal numbering, it's page 13. It should be headed additional matters.
Yes.
Thank you. What this follow-up audit did was it returned to the fact that 224 people had belonger status approved illegally in 2011, and noted that of those 224, 6 were part of a sample that was considered as part of the follow-up audit. And what the Internal Audit Department noted was that those 6 applicants had been made to go through the established process again. So having been given initially awarded belonger status, and this point having been picked up, at least those 6 were then made to go through the process of applying through the board. It then goes back to Cabinet, and Cabinet makes the decision. What the Internal Audit Department noted was it's uncertain if all the persons appearing on the list of persons who receive status contrary to the established process have had to go through the board to receive their status. Now, accept, Dr. Smith, that the decisions in relation to those 224 people were made by a Cabinet that you did not lead and you were not part of. But the reports raising the issue emerged in 2012 and 2014 when you were Premier. Did your Cabinet, in the time that you were Premier and led Cabinet, did you put in any steps to stop members being able to introduce applications for belonger status at Cabinet level?
During the time when we were in office, once we consider the recommendation by the board, there's always a discussion of maybe this person should have been included or maybe that person should have been included. But we did not alter the list. What we did was approved or disapproved the names of the list that was submitted by the Immigration Board. That is my recall.
So your evidence is I'm sorry, I'm repeating it just to make sure I can make this clear on the transcript, but it's that as a Cabinet, and is that both as the 2011 Cabinet and the 2015 Cabinet?
After we got into office in November 2011.
Yes, and
yes.
From then on, what your Cabinet would do was either accept or reject the recommendation.
Yes.
What your Cabinet did not do was at Cabinet level introduce applications for belonger status, irrespective of the board.
Not that I can recall. Sorry, could you just put that again and the last part of what you said?
Yes.
To be clear.
Yes. I'll put it this way. What was uncovered in the June 2012 audit was firstly that recommendations from the board were going to Cabinet. But in addition to that, members of Cabinet were introducing applications for belonger status themselves at that level without recourse to the board and deciding on that. So 224 people got belonger status without having going through the established process. And as I understand your evidence, it's firstly that as a Cabinet, what you did was either approve or reject a recommendation from the board, which I think you said yes.
That is correct, yes.
But also that as a Cabinet, what you did not do was yourselves introduce applications for belonger status that had not gone through the process.
No, what we would do, however, is members, during the discussion, members would suggest names of persons who they thought were deserving, and then these could then be forwarded to the board via the immigration officer who is responsible. But as far as I can recall, they were not subject to Cabinet's decision at that time.
So whilst members of Cabinet might suggest, well, there's someone who ought to get belonger status, that would still have to go back through the board to the board.
That's correct.
audit of June 2012 sets out and established the process that the board adopted, for which it was commended by the internal questionnaire. It had an interview, it had a point system, and it also had a queuing system. So it would look at applications based on how long they had been outstanding.
That's correct. Yeah.
If cabinet or a member of cabinet were to raise an individual as deserving of belonger status, and then a decision was made to send that to the board, does that not distort the process? Because doesn't it look as if cabinet are interfering, so that someone who could make an application in a normal way is in effect being given preferential treatment?
No, because the persons who, cabinet members may have suggested have been left out, but those who would have been within the particular years that the board had sent these recommendations. And knowing the board did what they were supposed to do as far as the law is concerned. They were not influenced by anything, and nor did we try to influence their decision.
And so what cabinet was doing was identifying people who cabinet felt ought to have belonger status.
Who may have slipped through. For example, if they were considering a particular 6-month period or 1-year period, and there were people who had been left out. My colleague may have noticed that and would make an observation. That
because the other limitation that was placed was that only 25 people a year could get belonger status under the policy.
That's correct, yeah.
And so if the board has identified 25 people who are going to get belonger status, or who they recommend for belonger status, and cabinet felt that there was other people who would qualify, doesn't it follow that some people would lose out?
No.
To keep within the quota of 25?
No. The cabinet never said to the board, we want this person or we want that person to be included.
What did cabinet say to the board?
What we said, not even to the board, we said to the immigration officer, this person would have fit within the period of time. The immigration officer made his recommendation to the board. The board made a decision.
Thank you. Could I move on to a different topic and a different report, please? And this is, I think, Commissioner, it's in the Part 3 bundle.
Yes.
It's about assistance grants managed by ministries. I think we need to go to page 2601. Sorry, 2691, please. Apologies.
Okay.
What we should have, Dr. Smith, is a report from the Internal Audit Department titled Government Ministries Assistance Grants Programs, August 2014, a draft report. The internal auditor explained that her department would label a report as draft in circumstances where there wasn't a management response. So if they hadn't received a management response, they would finalize the report, but still call it a draft report. this report was concerned with assistance grants programs that were operated by ministries, including the Premier's office. And it highlighted a number of concerns, which if I can, I'll just briefly summarize to you. The first was that there wasn't a formal procedure by which individual applicants could request assistance. If you want me to show you where that is in the report, please tell me, Dr. Smith, but if not, I'll just try and summarize it. The second was that applicants could make multiple requests to the same program and also could make requests for the same type of support across different programs run by different ministries. The third was that there was a duplication in terms of the purpose of the program. So, for example, your office as the Premier's office would run a program that had a similar purpose to that one established by the House of Assembly, on which the Commission has heard evidence. And the last was that the amount of assistance that would be awarded was left to the minister's discretion. So it was a decision solely for the minister to make. And if we go to let's go to page 2707, paragraph 11.1. In the conclusion, the Internal Audit Department said this: the assistance grants programs administered by various ministries is largely administered at the sole will of the respective minister. In their current state, these programs lack adequate controls to safeguard them from abusive practices. Various questionable practices have materialized that has resulted in one individual receiving multiple assistances across various programs and even within the same program. This is largely due to lack of verification activities and the lack of adequate policies and guidelines to govern the administration of the programs. The methods by which amounts are approved and the decision made lacks transparency, which casts a dark cloud over the programs. As I've said, there was no management response, but as we understand it from the internal auditor, this report would have gone to various ministries, including your office as Premier. It's a report issued in August 2014, when obviously you were in office. Was it a report? Do you remember this report being discussed at Cabinet?
No.
Within your departments, you were Minister of Finance and Premier. Did permanent secretaries raise the issues with you?
No, this report was not raised, it was not discussed. As I saw the word draft was a draft report. What normally happens is when the auditor, as far as I can recall, makes a report, she sends it, and the officer in the ministry, whether it's a permanent secretary, would make some comments and then send it back to the auditor, and then it would finally get back to the government. This was a draft which I have not seen.
I mean, that summary is right in terms of what it matches what the internal auditor said. But what she also added was that if the public authority that was being audited did not take the opportunity to make a management response, then her department that's the reason they would call it a draft report, not that it had more work for them to do, but because they hadn't had a management response. And the effect of not putting in a management response was that it meant that the report would be labeled as draft. I suppose my question is that this report, even if we call it a draft report, did at least go to permanent secretaries. It would have gone to permanent secretaries. And it raises a concern that grants programs within different ministries how they were used was solely at the will of the individual minister. But your evidence is that this wasn't brought to your attention by anyone.
No, I didn't. I did not see this report, and that is why I can't comment very much on it.
Leaving aside the content of the report, did the fact that there were grants programs within ministries, which for ministers to administer, did the way that those programs were being administered ever give you cause for concern while you were Premier?
When anybody made a request from a particular ministry, whether it's the Premier's office or the Ministry of Finance, there would obviously be a consultation with either the Permanent Secretary or the Financial Secretary before the Premier or the Minister made a commitment.
You've now obviously accepted your evidence is you didn't see it at the time in 2014. You've now had an opportunity to read it in 2021. Does its findings or its conclusions give you any cause for concern today?
I believe in audits. I think all organizations should have regular audits because audits can really help to improve the efficiency of the organization. So therefore, I would look at this and look at the conclusions, have a discussion within the ministry about it, and make changes if changes are indicated.
During your time as Premier, so 2011 through to 2019, were any changes ever made to the way grants programs within ministries were administered?
In 2006, I think, we made a recommendation. In fact, we decided that when we took the matter to the House of Assembly, to reduce the size of the grants. I think we reduced them by 50%.
But other than that decision, whilst you were Premier, were any other changes made to the grants programs that the ministries oversaw?
I don't recall, but no, I do not recall. But any suggestion by the officer in charge, that is my Permanent Secretary or my Financial Secretary, any of these grants would have been discussed with them, and they would have made some suggestion which could have been taken into effect.
I mean, I think when one steps back from that report, the point that we're left with is that it's how much an individual applicant gets, whether they get much, is ultimately a decision to be made by the minister. It's all at the discretion of the minister. And what there doesn't seem to be is any criteria either within ministries or across ministries by which that decision is made. Does the fact that there is an absence of criteria give you concern?
I hear you, what you're saying, but I would say that there's always a discussion with the accounting officer, whether it's the Financial Secretary or the Permanent Secretary, when these matters came up. I would agree that based on this, reading this now, it would have been in the right thing to do to relook at how the grants are being administered, and then come up with some process. One of the things, even all grants from the House of Assembly, I think there's a need for review in how they're managed, and particularly the accounting systems, how they're accounted for, so that it can be referred to. Because if the accounting system, for example, in the House of Assembly grants, if there was the records, then members would know that if somebody made an application to me for this particular thing, that already made another submission to someone else. Now, it does not mean that if somebody made some submission to another minister. Let's say, for example, they made a submission for $5,000 and the minister gave them $100. It wouldn't necessarily follow that they shouldn't make an application to someone else who may look at the situation differently.
But if somebody has a need for $5,000 under this system, there's nothing to stop that person making an application for a grant from a number of different potential sources, and those sources give him more than $5,000. It is. In fact, the more merit the application has, the more likely it is that more than one source will give him the full grant.
Yeah, but there was an informal discussion among ministers, and I don't recall that, occurring. It is possible, but I don't recall that occurring.
But there's no process. There's no process to identify whether it occurred or not.
That's what I'm saying. I don't recall. So you're quite right. There is no process, and this is why, as I said earlier, I think audits are important. And certainly, had I seen this then, I would have done something about it.
Thank you.
And the point you were making, Dr. Smith, earlier about that when an application was made, there would be a discussion within the ministry. Were you referring then to the practice within your own ministries, that if an application came into the Premier's office or the Ministry of Finance, that was the practice whilst you were leading those ministries?
Yes.
But what there wasn't was a discussion at cabinet level about how these programs should be administered, what criteria should be applied, etc.
No, there was not a discussion at cabinet level. And this is why, as I said before, audits are important.
Yes.
And they allow you time to review processes and put.
And you've made the point that audit is important and has benefits. In this case, this doesn't seem to be, or this wasn't a report that was responded to, for example, by the Premier's office, nor was it a report that was brought to your attention at the time. Why do you think that these reports weren't being brought to your attention at the time?
What year was this? Let me see.
It was August 2014.
14. Yeah, I cannot say. Sometimes things take a while getting from point A to point B. I cannot give an explanation.
Can I ask you a separate question, but related to the internal auditor? The internal auditor explained that she and her department report to a committee, which is the Internal Audit Advisory Committee. And that has 5 members. The Financial Secretary or Deputy Financial Secretary is 1. The Internal Auditor, the Director of the Internal Audit Department is 2nd. And then 3 other members of the committee have to be appointed by the Minister of Finance. Now, the evidence of the internal auditor was that the last established committee was set up on the 1st of January in 2014, and its term of office expired on the 31st of December 2016. Since then, there hasn't actually been a functioning committee. We understand that 3 members have very recently been appointed, but you have a gap from 2016 to 2021 when there isn't a committee, and the committee has statutory functions in relation to the Internal Audit Department. Now, you would have been Premier for some of that period, 2016 at least to 2019. Can you help the Commissioner with this? What was the reason for not re-establishing the committee after December 2016?
There was no reason for not re-establishing it. Once the matter is brought to my attention, then I would do something about it.
And whose responsibility was it to bring the matter to your attention?
It would have been whoever the chief auditor was, and which maybe who they were reported to, whether it would have come through either my permanent secretary or the financial secretary.
The Director of Internal Audit's evidence was that she wrote on a number of occasions to the financial secretary, including during a period when you would have been Minister for Finance. But as far as you can recall, Dr. Smith, the financial secretary did not bring it to your attention.
Certainly, I do not remember. I have no recall of seeing this document before.
Would it have been the job of the financial, in terms of finding suitable candidates for the committee, would that have been for the financial secretary to start that process?
Yes, he would have recommended, yes.
Because under the statute, the minister has to recommend names to cabinet, and cabinet then approves those names. So you would need someone to undertake that task for you. Is that right?
That's the normal process.
We've also given you, I think we've asked you to look at today some cabinet minutes, which you should have as a loose leaf set of papers. They've been paginated from 1 through, and the pagination is in the center of them. Do you have that? And if I just again set the context, it relates to Cabinet's decision to fund the construction of the wall at Elmore Stout High School. And if you look, the first page is the 4th of February 2015, and that's the actual decision that Cabinet made. If you look at D, Dr. Smith, Cabinet approved a sum of $828,004.10 to cover the cost. And it also approved, it gave approval to, granted approval to exceptionally waive the tender process. And then at C, we see that approval be granted to execute the project, utilizing petty contracts and different suppliers and contractors, and that the Ministry of Finance Project Support Unit assists the Ministry of Education and Culture with the management of this project. Now, I'm going to pause there. Can you remember, in terms of the Ministry of Finance Project Support Unit, when had that been set up?
Could you repeat that question?
If you look at C, 1C, it refers to the Ministry of Finance having a project support unit. And we're looking at a decision made in 2015. I just wondered whether you could remember when that unit was set up in your ministry.
I can't give you a date, I'm sorry.
Can you assist at all with what its purpose was?
The purpose was, as I said, the project support. The Ministry of Finance is the body which sends out the notices about contracts and also monitors to make sure that things are happening as they should. The project support unit, the unit that assists in that process.
So part of its remit was to make sure that projects were proceeding as expected.
Yeah.
And was that were they set up from the view of trying to maintain control over how money was being spent?
It was set up with a view of making sure that the contracts or the work was being done expeditiously and properly.
If you turn to page 3, please, Dr. Smith. This is, again, just so that you can orientate yourself through the papers, this is actually the minutes of the meeting of Cabinet. And if you see, you were not present at that meeting. you're recorded as absent overseas on official business. However, if we go through, you'll see at page 11 that the decision in relation to the wall was made on the basis of a cabinet paper, and specifically a memorandum from the Minister of Finance. Now, in circumstances where that's before cabinet, but you as Minister of Finance were absent, which member of cabinet would be responsible for putting the paper before cabinet?
The member of cabinet, which would be appointed, so to speak, as the acting Chief Minister, acting Minister of Finance.
I see. So in this case, what you were absent overseas on official business, as was the Honourable Cedric Pickering.
That's correct. Yes.
And so the Honourable Ronnie Skelton was acting Premier. And so it's there on the minute. He's acting Premier and Minister of Finance, so it would fall to him to put that paper before cabinet.
And that's confirmed in the minutes, Dr. Smith. You needn't look at it. It's paragraph 174, and it simply says the acting Minister of Finance presented this paper.
Okay, thank you.
But given that if you look, please, at page 13, however, in this memorandum, now, the memorandum is signed by yourself. I just wanted to ask a question about paragraph 12. What paragraph 12 says is the total project cost exceeds the procurement threshold and as such should have been tendered. The Ministry of Finance continues to advise ministries to utilise the tender process and not abuse the option to ask Cabinet to approve the waiving of the tender process. The tender process is in place to ensure that there is accountability and transparency. Proper and timely planning and prioritisation of all projects is necessary to achieve this objective. The Ministry of Education and Culture should consider their capital spending plan if Cabinet approves the decision sought. And it's that last bit that I just wanted to ask you about. As we've seen, the tender process was waived. The estimate that Cabinet approved was just a little bit over $828,000. Going back to that paragraph 12, where was the Ministry of Finance expecting the money to come from?
Each ministry had an allocation for capital works as well as recurrent expenditure. So it would have come from there, largely from there. It would have meant that they may have had to forego something else, the capital expenditure. This is why he said should consider their capital spending plan.
Thank you. So what the position was that whilst Cabinet would approve spending $828,000, it was up to the Ministry of Education to find those funds themselves from what had been allocated.
Correct.
And that might mean that the ministry might have to make different decisions in relation to other capital spending.
That is true.
What this wasn't, just so that we're clear, it wasn't Cabinet or the Ministry of Finance finding additional funds for this wall.
No, that last line was very clear.
Thank you. I just have a moment, please, Commissioner. Perhaps if you can help with this last question, and its relation to the decision to waive the tender in this case. Accept that you were not present at that meeting, but can you assist the Commissioner with why, in your view, tender waiver was appropriate in relation to this particular project?
Reading through this document and also from knowledge, the Minister was very concerned about illegal activities around the school. including illegal entry, including use of cocaine and various things like that. The chief of police was also very concerned, and they thought it was important to do something to protect the lives of the young people who attend that school.
Thank you. Commissioner, I've reached the end of my questions. So can I just conclude firstly, but once again, thanking Dr. Smith for returning and assisting further with the Commission's work, but also secondly, thanking him for the way in which he has given his evidence today.
Yes, and can I again thank you, Dr. Smith, for coming, for your time, and for the helpful way in which you've dealt with all of the questions. Thank you very much.
Thank you, Commissioner. Thank you.
Thank you. Can I ask you, Commissioner, just to rise now, because we're going to have a pause. We've got a directions hearing listed and then a witness coming at 2 o'clock.
The directions hearing at 1 o'clock.
At 1 o'clock.
Witness at 2 o'clock.
Witness at 2.
Thank you very much, Mr. Wright. Thank you, Dr. Smith. at 12:20, and understandably, Mr. Rowett wished some time to prepare for this directions hearing following the hearings of this morning, which concerned further evidence. One point made in the letter that we received from Withers was questioning whether this hearing should be in public or private. I have no doubt that it's properly in public. These matters, in my view, should not be aired simply in private. There's no good reason for them to be so aired. Mr. Rowett.
Commissioner, with your leave, what I would like to do is just, by reference to the points that are set out in numbered form in the Withers letter.
Do you want to just confirm who's
yes, that's,
for the purpose of the record, Mr.
Thank you. For the purpose of the record, in terms of legal participants attending remotely, Ms. Sara-Jane Knock appears on behalf of the Attorney General and the elected ministers. Mr. Daniel Flingerson Davis appears on behalf of other remaining members of the House of Assembly.
Good, thank you very much.
And in terms of the matters that we need to canvass this afternoon, what I suggest I do is I would just adopt the sort of sequence of topics as set out in the Withers letter.
Yes.
Just sort of numbered, really.
Certainly.
The first point that on which the IRU takes issue is a point made in correspondence by the Commission that the disclosure being provided by the IRU is disorganised and unhelpful. And this is a letter from Mr. Olympitis. He was in correspondence given one example in relation to 11 documents, 31 pages, and his response was that the documents were clearly marked. It took him no longer than 5 minutes to ascertain the order that the documents should be in. And he makes the point that so far as he was aware, the COI was content with the recent arrangements that were made regarding disclosure. With respect to Mr. Olympitis, that doesn't really answer what is a bigger issue. And that is that what is continued to be provided to the COI is material that is being received out of order. And one other example that I can give is in relation to cabinet minutes. You'll recall, Commissioner, that at the start of this process, material was being received by the Commission that wasn't in an organised fashion. And that was a point that Sir Geoffrey Cox conceded at an early hearing. The cabinet minutes, and for good reasons that will be obvious, those are documents in which the COI will have a significant interest, were disclosed anew by the IRU, and they were admittedly in better order than they had been, but they were uploaded by year and then minute and then the memorandums, i.e. that is the underlying cabinet papers. And it's at that point, that last stage, where once again difficulties arose because almost inevitably the papers were out of order. And it doesn't, for Mr. Olympitis to dismiss the problem in the way that he appears to do in his letter, doesn't really answer it. It's, I mean, one could perhaps glibly respond that given it took him 5 minutes to sort out, it should be no hardship for Withers, given their substantial resources, to be able to do it on a routine basis. The point is that it only introduces delay in the work of the COI if material is provided out of order. And the best illustration I can give about that are the first hearings that the Commission did in private, where with a number of witnesses, we took them through documents, and in an effort to ask for their assistance to try and understand the process by which, for example, a contract was entered into, and where time and time again, witnesses were having to say, well, I'll have to go and check that and I'll come back to you. As to the point that Mr. Olympitis makes under this head is that the COI was content with recent arrangements. That again doesn't really appreciate the point. It's not a matter of, well, you haven't complained. The position that the COI is being placed in is that it has to just put up with this situation in order for us to continue the work of the inquiry. And frankly, we should not have to be, it should not be expected that we need to raise issues of this sort with a global firm that's providing a commercial service. And so I hope that I've set out there why this is such an important issue for the COI. Perhaps I can link it to the second point, which is about the use of references. At the beginning of the Commission of Inquiry, the IRU were asked not to use their own references, but they continued to do so in correspondence and when providing disclosure. The way that documents have been referenced when it's being disclosed onto the relativity platform that the COI now uses has caused problems, and we've had to find workarounds. And that's the point that we need to get across today is firstly that the IRU, and the IRU has put itself at the center of this process. It wants any disclosure from any government body to go through it. It wants to be able to conduct, as we understand it from previous correspondence, an audit exercise. If it wants to do that, what it needs to do is to ensure that when it's providing disclosure to the COI and to relativity, not only that they use their own reference, but also that they use the reference that the inquiry uses, because otherwise the process slows down. And contrary to the assertion that's made by Mr. Olympitis in his letter that the COI has often referred to the IRU's reference alone for ease of identification, that is not so. This commission has had to use those references when it's had to draw attention to an error on the part of the IRU or to seek clarity. And one example has been given to Mr. Olympitis, and that is where the IRU uploaded material under one reference set out in a covering letter, but that material was then disclosed under a second reference. And these may appear to be small points, but given the pace at which the inquiry has to work, they can rapidly build up and they can destabilize the hearing timetable. And that's what we are most keen to preserve.
In respect of the references, Mr. Rawat, there are now two references, the IRU's reference system and the Commission's reference system. Are you saying that the IRU can or even should use both references on any particular document, as long as they use them correctly?
What has to happen when as I understand it, when material is provided now to relativity, both references have to be used, and that's to ensure that it can be properly indexed on relativity, and that's it's a workaround that's been reached to ensure that the material can be uploaded and retained on relativity and appropriately indexed.
But the message to Withers that you give is, please put both references on everything correctly.
Yes, I mean, we can set that out in writing, but both references have to be used as I understand it, but also it's very important, obviously, to get references right.
Yes, okay. Thank you very much. Now, Ms. Knock, we'll come back to that. In relation to the first matter, where Mr. Olympitis didn't agree that the disclosure was disorganised or unhelpful, as I understand it, even in the example that was given, which was a tiny example, 31 pages, the documents which were in appendices A to H were not put in the order as one might expect, A, B, C, D, E, F, G, and H, but were simply put in a random order. And that, on any view, is not helpful. If it took Mr. Olympitis 5 minutes to sort out what order they should be in for 31 documents, That some of these exhibits are hundreds of pages long. I just don't understand why they put in an order which is not clearly the order they were in, and indeed no sensible order.
Commissioner, thank you very much for giving me the opportunity to address you on these issues. I'd first like to point out that the numbered paragraphs in the Withers letter are responding to the numbered paragraphs in the in the Commission letter that we received last night at about 7:45 p.m. in the BVI. I'd also like to start off by discussing how disclosure has been provided to the Commission from the very beginning. Now, Mr. Commissioner, please afford me the respect and allow me to finish. Because a lot has been said about the IRU's failings to provide disclosure, and I would like to have the courtesy of addressing the Commission without being interrupted by you, sir. So I will start.
First, Ms. Knock, first, could you please answer my question?
I will not answer your question first because we have to put it in context, and then I will get to your question, Commissioner. At the very beginning of this inquiry, the BVI government employed a document management provider called Disco. At the very beginning, in February, the Commission has been offered access to that platform numerous times, and you have refused access to that platform. Had you accepted that offer, you would have received the documents in exactly the same way that the IRU has received the documents. Instead, we have been asked to provide documents by email, which we did. We have then been asked to provide documents by share file, which we did. We have then been asked to provide documents by relativity, which we did, which means that sometimes we have provided the same document at least 3 different times. Every time we have provided a document, we have not only referred to your reference, but we have referred to the IRU's reference. So Mr. Rawat is incorrect when he states that we only use our references. That is not true. We also provide an inventory for all of our documents, which clearly state which request they relate to. So again, Mr. Rawat is incorrect when he states that. When we provide documents uploaded to Relativity, we also send an email saying where they are filed, and we provide an index, and we provide the Commission reference. Now, with respect to the Cabinet minutes, some of these have been provided 3 times. And as we have previously stated, they are provided in the same way that the Cabinet provides them to us. After we were told that you wished them in a different way, we uploaded them in a different way. We spent days and days organising them for you. Now, Commissioner, there are only 11 documents in this recent example that Mr. Rawat has indicated. They are provided to you in the same way. There is an index. It is clearly they're clearly stated. They can only be appendices to the same document. They are not all included in one document. They are all separate. We provide them to you in the same way that they are provided to us. It is for you to organise them, not for us to organise them. That is the answer to all of these criticisms. We have been providing the documents as we have been given them. We have been providing you with both our references and your references, and we have been providing them in many different formats over and over and over again. All of this could have been avoided had the Commission taken up our offer numerous times to have access to the Disco platform, which is a very similar platform to Relativity. Instead, the Commission only started using Relativity very recently.
Ms. Locke, I don't want or need to go through the entire history of the way in which these documents have been disclosed. There were very good reasons why we didn't want to share the BVI government's platform, one of course of which is the need to have a platform which is under our control, which I regard as being very important. But from what you've said, and in response to the question I put at the beginning, you accept that documents which are not put in the order A, B, C, D, E, F, G, and H, but in a random order, is disorganised, but you say that that's the order that you received them in.
Commissioner, have you had a look at the index for those documents? Have you seen it?
But these are the documents.
No, Commissioner, have you seen that index? Can you honestly tell me, when you have a look at that index, that it is difficult to understand the order of those documents? Have you seen the index?
I haven't seen the index. My team have seen the index, but that's not the point, is it?
That is the point, Commissioner. We are trying to provide you with hundreds and thousands of documents. We are trying to do it as quickly as we possibly can. And we are doing it in the way that we have been provided with those documents. They are clearly labeled, they are indexed. Now, 11 documents on an Excel spreadsheet, which clearly state Appendix A, Appendix B, Appendix H. All you need to do is click sort on an Excel spreadsheet and they can be sorted. It is quite frankly ludicrous to suggest that they are provided in a disorganized, unhelpful way, Commissioner.
Looking forward, which I'm very anxious to do you therefore propose to disclose documents in the same manner?
Yes.
Mr. Rawat.
I think we've taken a long time to get to a short point. And we've done it by generating a lot of heat and not very much light. The point is, the example that I gave, and the reason for giving it was that was given as a recent example in relation to correspondence. The issue that the COI is taking is not that on one occasion 11 documents were sent in a particular fashion. This is happening, this is a wider issue. But I think the answer that the Commissioner, you are being given is basically, this is the way the IRU gets it. This is the way the Commission will get it. And I think that's the end point.
Will that slow down the preparation, your preparation and the COI team's preparation for hearings?
Inevitably, and the example of that is we end up going back to the point that we were with our initial hearings, that we are having to sort out. And with respect to having the fact that the COI has been given documents more than once, all that means is that it's been given documents in a disorganized fashion.
That is not true, Mr. Rawat.
Ms. Knock, you can't interrupt, I'm afraid. That's not the way we do things.
But I think that's the logical conclusion. I mean, Ms. Knocker's point is that the material is given in the way that it is received. So if it is received in a disorganized fashion and then given by email, it is still in a disorganized fashion. If it's given by SharePoint, it is still in a disorganized fashion. If it is uploaded to Relativity, it is still in a disorganized fashion. I think that Ms. Knock's submission simply comes to this. One, it is handed over to the COI in the manner that it is received, and two, the IRU does not consider its role to in assisting the Commission to in any way organise the material and in a fashion that would allow it to be followed.
That is not my submission, Mr. Rawat. If that was the submission, we would not index the documents for you in an Excel spreadsheet that can be clearly sorted. I take issue with that submission.
I'm not sure, Commissioner, that we're going to get much further with the point.
I don't. It's unfortunate.
Yes.
Sir Geoffrey Cox accepted that the documents in the hands of the BVI government were in a very, very poor state. I had hoped that the intervention of the IRU, which is, as I understand it, to assist the Commission of Inquiry, would have assisted in organising those documents in the way in which I would find it most helpful to deal with the hearings, which we are proceeding with at great pace. But anyway, you have made the position of the Attorney General clear. Point 3, Mr. Rawat.
I think the point 3 and successive points overlap to some extent. So can I break it down in this way and take point 3, narrow it down just to the compliance with the Commission, with your protocol, Commissioner, on the provision of written evidence in relation to providing it in electronic form. The protocol, which is dated the 1st of June 2021, asks that the affidavit be accompanied by an index which sets out or indexes exhibits. And secondly, it also asks that an electronic version of the affidavit be provided in Word form. In a significant number of cases, there is no index provided. A Word version of the affidavit is never provided. Again, it's not clear why the IRU can't do this. It's somewhat baffling that it isn't, because these are not requests that are complicated or outside the normal course of requests that an inquiry would make of participants. So that's the first point I wanted to raise. Perhaps if you invite Ms. Knock to respond to that before I go on to the next point.
Ms. Knock, what's the response to that?
The response to that is we'd like to know why you need it in Word format.
Because the protocol says so.
That's not an answer, Mr. Rowett. Why does the Commissioner need the affidavits in Word format?
Ms. Knock, there are two answers. Firstly, because the protocol requires it and participants are required to comply with the protocols. Secondly, because as we work with the evidence in the affidavits, it is much easier to be able to take parts out of a Word document and put them into other documents, such as submissions, if something needs to be referred to or responded to, or indeed the report. But the real answer is the one Mr. Rowett gave, and that is that it's in the protocol. Are you saying that the Attorney General doesn't have to comply with the protocol?
I'm not saying that, Commissioner. If you insist on having them in Word versions, then we will provide them in Word versions, but it will take some time to obtain those, because often the IRU doesn't have the final Word version before they're provided by the various ministries and public officers. So we will do what we can to provide those for you.
Good, thank you very much.
Can I clarify just 2 points with this? Firstly, it's whether Ms. Knock is making, I've assumed that Ms. Knock is making submissions on the instruction of the Attorney General. So we need to be clear whether the Attorney General wishes or will in terms on written evidence or not.
My understanding of your answer, Ms. Knock, is that the Attorney General does intend to comply.
Well, we'll get to that bit, Commissioner, because there are parts of the written protocol that we take vast issue with, and we have made that position very clear in correspondence. So I'm sure we'll get to those bits. For now, the Attorney General will comply with the provision of Word versions of all the affidavits. But as I said, that will take some time, not least because a majority of the ministries are shut because of the pandemic.
Ms. Knock, let's take it a step at a time. We've dealt with that.
Yes.
Can we deal with the step of whether affidavits will be accompanied by an index?
An index of the documents that are in the exhibit that are referred to in the affidavit. You would like the IRU to go through all of the affidavits and produce an index of all of the documents in the exhibit, Mr. Rowett?
No, it's not, Mr. Rowett. It's what's required in the protocol by me as the Commissioner.
Commissioner, are you asking the IRU to go through all of the affidavits and provide an index of all of the documents that are already referred to in the affidavits?
Because that's what the protocol requires, and that's what will save time during the course of the hearings. That's what should have been done already. It's not an additional task.
Well, it is an additional task because you have asked for so many affidavits. We've just been trying to get them to you as quickly as we can. If you would like those indices, we will provide those indices, Commissioner.
It's not an additional task. It's a task which simply hasn't been done. But thank you for confirming that we'll get the indexes, Mr. Rowett.
Could we move on then to the next topic, which is question of redaction?
Yes.
Now, the protocol on redaction set out a two-stage process in terms of disclosure and in terms of redaction. So what the protocol also does is that it reserves the COI's position that it can invite redactions at an early stage. And in letters of requests seeking disclosure and seeking affidavits since in more recent weeks, the COI has made clear that it needs recipients to indicate what redactions they seek when providing that disclosure or providing an affidavit. And we've had to do this because of the time that recipients of affidavits have needed for to actually comply with requests. There has been just one occasion when, Commissioner, you have refused an extension of time. There have been 2 occasions when you have only agreed a partial extension. Otherwise, or in every other instance, requests for extensions have been granted time and time again. But that obviously has an impact on the timetable. And it also has an impact on the work of the COI because it reduces the time we have to consider material that is coming in, to determine whether we need to ask someone to come along to attend an oral hearing, to decide whether to prepare a summons to issue them, to organise the hearing. That's the sort of price we have to pay in order to ensure that people can provide affidavits. But so far, the Attorney General has not sought redactions in relation to any affidavit that has been provided, but there is a lack of clarity as to whether she will seek redactions in the future. And I can illustrate that by taking you to the affidavit, to a standard sentence that appears so far in all affidavits that the COI has received, which is that at the outset, I should further say that in this affidavit where I mention the document, I do not waive any privilege asserted in respect of it, unless I do so expressly. Now, the difficulty with that is that the witness is effectively, or the affidavit maker is effectively reserving his or her position. And it's not entirely clear when matters will move forward. It's not clear from that sentence what kind of privilege may be asserted. It's not clear when it might be asserted. And as you will appreciate, Commissioner, that obviously can have impact on a hearing. The COI doesn't know the extent to which the Attorney General is happy for it to use the affidavit and its exhibits. And it doesn't know whether, if it does use it, whether there will be a belated request for a matter to be redacted on the basis of privilege. And so what I would like to understand, or in my submission, it would be helpful for you to understand from Ms. Knock, and it's not what the IRU's position is, because the IRU acts under the instructions of the Attorney General. So it's the Attorney General's position that needs to be made clear. And is it the intent of the Attorney General to comply with the requests that is set out in letters of request, and that is to identify when, for example, submitting an affidavit, what redactions may be sought? Yes, Ms. Knoll.
We have already answered this question in correspondence, Commissioner. I'm not sure what else we can say to this question. We've already answered it.
So what is the answer, Ms. Knoll?
The answer is that privilege is maintained.
Privilege? What privilege?
The privilege in the documents. Now, we have not expressly said for any of the affidavits that we wish any of the documents to be redacted. However, there may come a point in a hearing where a document arises in an exhibit and is mentioned. And so we wish to maintain our right to say that we maintain privilege. We've set this out in correspondence before. I'm not going to speak more to it.
Does that mean that the Attorney General reserves her right in the middle of a hearing when we're going through the evidence to bob up and suggest that something is privileged?
Yes.
Then to set out what the privilege is, and the basis for it, and then we can have a debate and a decision on the privilege in that document.
Yes.
Well, but there are. I mean, Mr. Rowett may have something to say about that, but there are obvious problems with that, because if we knew what documents or information the Attorney General considers is or might be privileged, the chances are, for most of it, that we can work around that. But we can't work around it if we don't know what, if anything, she is claiming privilege over, and on what basis.
Commissioner, we will do what we can, but as you will appreciate, we have been asked to provide affidavits and documents in incredibly short periods of time, even with extensions. So when we are able to assert privilege and say that we request redactions prior to a hearing, we will. However, we still reserve the right to raise an issue of privilege during a hearing if it so arises. And that's all I can say. Those are my instructions, Commissioner.
Anything else, Mr. Rowett?
Well, it's not the most helpful position for the Attorney General to take. It's difficult to understand why, in the process of compiling an affidavit, identifying which material should be exhibited to it, and perhaps I have wrongly assumed that these affidavits are being prepared with the assistance of legal representation, but it is difficult to understand why issues around redaction cannot be identified at an early stage. And it's wider than the question of privilege, which is what Ms. Knock has focused on. It's whether what's also asked, for example, is whether the Attorney General wishes any personal data to be redacted. And the point is that the practical consequences are obvious and significant. Firstly, that if any participant suddenly at the last minutes in relation to a document where they could have given an indication at an earlier stage steps up, then we will have to stop the public live streaming. Secondly, there would then have to be discussions about the extent to which a document can be deployed and a ruling may be necessary. And depending on that ruling, there would have to be further discussions as to how the document was deployed. And although, Commissioner, you have been prepared to sit late to get witnesses done, the obvious inconvenience and disruption is there. But we have Ms. Knock's submissions as to the position of the Attorney General.
Remind me of this, Mr. Rowett. There was some earlier correspondence about reductions. Didn't the attorney suggest that we gave a certain number of days' notice? If we wanted to, this is for stage 2.
The Attorney General's position, and I'll be corrected by those who sit behind me, was that she, if the inquiry were to indicate any redactions that it wanted to make, she could deal with that within 2 days. Just going to turn to check whether. And that's been confirmed by those who sit behind.
Yes, that rings a bell. But the problem, presumably, is that the affidavits are coming in so late.
Yes, but it's the way we are going to proceed is that if there is no positive response to what's clearly set out in the letters of request, then seeking redactions, then we will have to assume that no redactions are being sought, and we will proceed on that basis. And we in terms of what the letters of request seek, that they explain to recipients of a letter of request, for example, seeking an affidavit, that if they are redactions sought, then they will need to produce a marked copy of the affidavit, marked to show the redactions and then fully redacted. But I think, as I understand the Attorney General's position through Ms. Knock, it is that no redactions are being sought, but she reserves the right to raise an issue of privilege at a hearing. But I'm assuming, and no doubt Ms. Knock will correct us if we're wrong, that reservation is limited just to questions of privilege and nothing else.
Is that right, Ms. Knopp?
Yes, but also redaction insofar that it relates to privilege.
Well, I'm sorry, I simply don't understand that. Ms. Knopp,
So if I'm going to be raising an issue of privilege and therefore the document needs to be redacted, then therefore it's redaction and privilege in respect of that document.
well, the only way we can proceed with hearings, if that's the Attorney General's view, if that's the Attorney General's stance, it is to proceed on the basis that the evidence that's been submitted to me, that no claim is made, we're going to assume that no claim is made for privilege. If a claim is made at some other time, even during the course of a hearing, we will have to deal with it then, because there is no other way of doing it. But we're going to assume that there is no claim for privilege, no claim for any redactions in any of the documents that have been lodged. Good, Mr. Rowett.
I think if we can move on to the next matter, and that is a request which was set out in an email 7th of July 2021, which is addressed to the Secretary to the Commission, and that's in relation to an extension of time in relation to a number of affidavits. This was sent by Ms. Knock, and the extension that is sought is to Wednesday, the 14th of July, 2021. Commissioner, we would, or in my submission, that there will be no difficulty in granting that extension in principle. What Ms. Knock asks for is some indication as to the priority order, and we can write to the IRU after this hearing to set out which matters may or need to be prioritised in order to best preserve the hearing timetable. I mean, the point that Ms. Knock makes is that the IRU, I mean, the requests don't go to the IRU for affidavits, they go to the person who's being asked to make the affidavit. As I understand the guidance note that was issued by the Attorney General, it's up to that person whether they wish to use the IRU or not. The Commission does routinely copy in the IRU to emails, but what I think, 2 points I think bear keeping in mind. First, that it is not unusual for an inquiry to seek, here it's affidavits, in other inquiries it will be witness statements from witnesses explaining circumstances, and that's inevitable. That we have to do it in short time is a consequence of the timetable that the inquiry operates under. That it might be said that there are many requests, well, that's a consequence of two things. Firstly, the terms of reference, and secondly, that there are a number of matters that you, Commissioner, consider it important that you investigate in order to fulfil those terms of reference.
But also, Mr. Rowett, because this was dealt with when I directed these affidavits to be requested and made. Quite a lot of these affidavits are required because the documents that have been produced are in no sensible order. The only way of understanding what might have gone on is to get somebody who should know what's gone on to set it out in an affidavit with the documents insofar as they're available.
And the point I would add to that observation, Commissioner, is that the affidavits are being sought in relation to documents that have been provided already. So if I use the example of one that we have sought, which is in relation to Crown land, you will remember that we had hearings in relation to Crown land. And so the disclosure was provided. Following that hearing, you directed that further material be identified and provided. And so the next stage is to ask someone to take the material that has already been identified as relevant and explain it in effect. So that's the context in terms of the extension time, but I would just raise one other matter that arises out of the question of affidavits. On the 2nd of June, you set out the topics that you were going to investigate, and with some changes, our hearing timetable has adhered to that. And so at the moment, the topic we've been looking at is the work of the Auditor General, the Complaints Commissioner, and the Internal Auditor. As we move through, we will move on to the question of the function of statutory boards. We will look at Crown land, and we will look at contracts. And these are what the requests for affidavits are going to. And so, but the point I'd like to make is not about a provision of new affidavits, but about the content of those that have been received following grants of extensions, but which don't appear to have fully answered the request. And if I give an example, and it is an important example, but the COI sent a letter of request to the Honourable Premier, but as Premier and Minister of Finance, asking that he set out in an affidavit the details concerning the statutory boards that fall under the remit of him as a minister. Similar letters of request were sent to others. In relation to the affidavit that's been recently received from responding to that letter of request, what is quite clear is that the affidavit has not addressed a number of, and in fact it's 8 statutory boards that actually come under the Premier's portfolio. And that's not from the COI. It's actually set out in a cabinet memorandum as that these are these statutory boards come under the cabinet's portfolio. So what you therefore directed was firstly that and this was in a letter to the Attorney General, that by 4 p.m. today, you be provided with a list of all statutory boards for which ministers hold responsibility, and a detailed explanation as to how there now appears to have been a serious failure to comply with the request to address all statutory boards. Particularly, the letter says in circumstances where the IRU has been assisting, we assume perhaps wrongly, with the preparation of affidavits. Secondly, that insofar as that list is provided, it should contain statutory boards or identified statutory boards that are not addressed in the affidavit, and the relevant permanent secretary or minister that will provide a further affidavit addressing the matters concerning those statutory boards. And what was asked also was a specific affidavit be provided by Dr. Carolyn O'Neill-Morton. Now I'm summarising that. I think what's important, I've dealt with the request for extension, but what perhaps is important to hear from Ms. Knock-On is whether that request for clarification by 4 p.m. today will be met.
Mr. Rowe, you've gone through the programme of topics that I set out at the beginning of June. As you say, at the moment we're really dealing with matters arising from the reports of the Auditor General and the Internal Auditor, and that's going to take this week and probably next week. Next on the list of topics would be statutory boards.
It would be.
So this would be the next topic.
Yes.
So this is likely to start a week on Monday.
Yes.
And right, okay. Yes, Ms. Knock.
Thank you, Commissioner. First of all, I'd just like to reiterate that it is not through lack of will of any of the public servants that things have been submitted late. They are everybody who the IRU is dealing with, everybody who the Attorney General is dealing with, is going to great pains to provide the Commission with what they need. And unfortunately, it takes time, which has been the reason for all of the extensions. Now, also, unfortunately, as you will be aware, the BVI is currently in the midst of a huge COVID-19 surge. In fact, it is the worst surge that the BVI has experienced since the COVID pandemic. Currently, there are reported 821 people who have received a positive COVID-19 test. Now, the knock-on effect of this is that the current guidance is that everybody is suggested and asked to not travel, to work from home as much as they can. And what it also has meant is that many of the public offices and ministries have shut. In fact, I've been provided with a list of every office and ministry that has been closed as of today, which I can certainly forward on to you. With respect to the Premier's office, they had 2 positive cases yesterday and they've had to shut for at least 14 days. So whilst we will continue to do everything that we can. And when I wrote my email yesterday, we thought we were going to be in a position, everybody thought they were going to be in a position to provide you with the affidavits by next Wednesday. I can't say that that will be the case, because not only are people working remotely, they don't have access to the same IT facilities, they don't have access to their staff, they don't have access to hard copies. And today when I spoke to the Permanent Secretary of the Premier's office, she stressed to me she would do what she could with her staff to provide you with the documents, but they would only be electronic documents, so there may be gaps. So it is unfortunate that this surge has happened now and it has caused disruption, but there will continue to be disruption. I'm receiving phone calls from people in hospital asking me to please request an extension, from phone calls talking about their sick children and their sick relatives. And so there is not a lack of will to provide you with these documents and these affidavits. They just simply need more time. With respect to the statutory board's information, we will provide that to you as soon as we can. We have been asking the permanent secretaries to confirm the information. We got the letter, I think, 2 days ago. We've been working with them. But as you will appreciate, not only are the permanent secretaries working to provide the Commission of Inquiry with what the Commission requests, but they are also working to run a country. So we are doing what we can, particularly with short deadlines. We will be providing the affidavits, or I'm instructed that the recipients of requests for affidavits are working hard to provide them as quickly as they can. They may not be as detailed as they would ordinarily be because they simply don't have the resources at the moment to provide them. And that's all I can say. We're asking for some compassion from the Commission. We're asking for some understanding that if deadlines are missed, it is not because people are not trying. They are doing everything that they can to get you what you need, Commissioner.
Ms. Knopp, firstly, and I've said this before several times, but I'm very, very pleased to reiterate it. I very much appreciate the efforts of the public servants in doing the work that they have to do, because all or almost all of this work has been delegated down from ministers to their public servants. Their work in providing the Commission with the information that they have provided, both in terms of documents and now in terms of affidavits. Secondly, I am, of course, very sensitive. We're all very sensitive to the health position here as it's developed in particular over the last week. And we understand the challenges that brings in all sorts of ways, but including in responding to the requests the Commission are making. But we're very, very sensitive to that. Of course, most of these requests were made some time ago, long before the unfortunate COVID surge. But what I'm far more interested in is to ensure that the work of the Commission can proceed as best it can, sensibly and safely in the circumstances that we find ourselves in. My understanding, but Mr. Rowett will correct me if I'm wrong, is that the work of the Commission over the next couple of weeks, which, as I say, concerns topics relating to the reports of the Auditor General and the Internal Auditor, there are no outstanding affidavits for this week or next week, as I understand it. I'm just checking, but that's the case. So in terms of the evidence, we have the evidence set up for this week and next week. I've given directions in terms of how we're going to proceed, which is of course remotely. But the next topic will be statutory boards. And so relating to statutory boards, and the affidavits relating to Crown land. In terms of the statutory boards, we asked for the gaps to be filled by today, by the end of today.
It's really to sort of understand where the gaps are as a first stage, or why there were gaps in the first place. I mean, some of these affidavits were requested at the beginning of June, so and it is concerning that if they're going to come in and incomplete, then we need to take a view. I mean, it doesn't just affect the timetable. We need to consider then the best way of filling in the gaps so that we can have focused hearings rather than having to bring people back.
No.
And that's particularly difficult if, as you say, as pointed out, and as everybody knows, the COVID situation has now changed.
So the response to that letter, Ms. Knock, is vital for the term in terms of our timetable, because Mr. Rawat and the COI team supporting me do need time to prepare for the hearings. And secondly, Crown land. And my understanding, but correct me if I'm wrong, is that you're suggesting, subject to everything else being equal and things not becoming even more adverse, but you were at least hoping that those would be sent in by next Wednesday.
Yes, I think at the moment there are 13 or 14 affidavits that you have requested that are outstanding. And so we are working as hard as we can with, and I know that the recipients of requests for affidavits are working as hard as they can. As you have been told before by Sir Geoffrey, we're working with an understaffed public service here, and they're trying to do what they can. And I appreciate that you have said that statutory boards will be the next topic. We will work to get you that information as soon as we can. We appreciate that you do need the time to prepare. It's not going to be possible to get your list today by 4 p.m, particularly what's happened over the past 2 days. So we will get you that information as soon as we can. We will be providing you with the affidavits as and when they are finalised. It may be that the affidavits actually are witness statements rather than affidavits, because the recipients may not be able to find notaries or commissioners of oaths at the moment. But rest assured, we are doing what we can. We do not want the commission to continue any longer than you want the commission to continue, Commissioner. So we're doing it. It is not for lack of will that the extensions have been granted. We're working with a very understaffed public service here who are trying their best, and a lot of the affidavits are addressed to the same ministries, in particular the Ministry of Finance and the Premier's office, and they are doing what they can to give you the information. Now, if there have been gaps in the information that they have provided, then once those gaps are identified, they will work to provide you with that information.
No, Ms. As I say, I understand the pressure that the public service is working under, but with respect, it is not up to the Commission of Inquiry to identify gaps in statutory boards where the ministers must know which boards fall under their umbrella. And as Mr. Rawat says, that the Premier / Minister of Finance's response appears to be 8 statutory boards short. So it's very important that we get some handle on when we're going to get the substantive information concerning statutory boards. And the letter that's outstanding really goes to that issue. Why have these been missed out, and when can these gaps be filled? But it's obviously for the ministries to identify the statutory boards that fall under their umbrella. If they simply can't identify their own statutory boards, that will tell a particular story, but I suspect that that's not the case. So could you come back to us by the end of tomorrow, which is a Friday, at least telling us what the position is with regard to the evidence on statutory boards?
Yes, Commissioner, we will do so.
Thank you very much. And similarly on Crown land, if you could make inquiries about Crown land, because you've said that you hope to get these affidavits in by next Wednesday, and I certainly understand the point you make about difficulties in swearing affidavits. Currently, I understand that, and statements which can be sworn later if necessary would of course be fine. But again, in terms of Crown land, it would be helpful for us to know by the end of tomorrow, so far as you're able to ascertain it, where we stand in relation to getting the affidavits in relation to Crown land together and to us. Because we are working towards dealing with those topics in the next couple of weeks.
I understand, Commissioner. We will do what we can.
Good, thank you very much. Anything else, Mr. on that topic?
If I may be of assistance.
Yes, Mr. Davis.
Well, what the Labour tribunal does in such situations, me having been in a few matters myself, is that affidavits are sworn remotely by their commissioner of oath, who happens to be the secretary to the tribunal. So a signed copy of the affidavit is sent to the or a copy of the affidavit is signed. She takes the oath on video, and then it's scanned in and sent to her. If that procedure may assist, the similar procedure can assist.
Thank you, Mr. Nicholson Davis. I mean, Miss Knott will note that. As I say, at the moment, I'm interested in the substance of the evidence, because the formalities can be dealt with in another way or later if necessary. But Miss Knott, you've heard what Mr. Davis says about that. That may help.
Yes, thank you, Mr. Davis.
Right.
Just, I think in terms of trying to find a pragmatic way through, I think the two key things to emphasize is if Ms. Knott can come back to us and give a realistic assessment of firstly, the reason why there were gaps in the statutory board's affidavit, secondly, how those gaps will be filled, and then thirdly, the position on producing an affidavit in relation to Crown land, because that then will allow us to plan realistically for the weeks to come.
Exactly.
The one final observation I would make, though, is that perhaps it's important to point out that the letters of request go to the minister. So the request for an affidavit is, be it to the Premier or the Minister of as Premier or Minister of Finance, or to another minister. It goes not to the ministry, but to the minister. And it is then a matter for the minister to decide whether he will provide the affidavit, or whether he will ask someone in his ministry to provide it. The Commission has always recognised the efforts that have been made by public officers to provide it with information, and that has not been reiterated by yourself, Commissioner, from time to time, but also directly to those officers when they have given evidence. But perhaps it may be that the Commission has been proceeding under a misapprehension that those who are providing these affidavits have the benefit of legal support in so doing. I don't know whether Commissioner Ms. Knock might be able to assist you with an explanation of what support is being provided to these public officers if they are being asked to make affidavits by their ministers.
I've assumed, Ms. Knott, that the IRU stroke the AG's chambers are supporting the ministers and other public servants in producing the affidavits that they are producing.
We are providing whatever support that the ministers and public servants request.
Well, there we are.
Right. I think the penultimate matter we need to deal with is the question of the Commission's request for hard copy bundles. And this is set out in the protocol, and that is that in addition to the material being provided in hard copy, then it should also be provided in electronic copy, forgive me, it should also be provided by in hard copy, and the protocol asks for 5 hard copies. Perhaps it might help, Commissioner, if I just give some context as to why the protocol does say that, and why it doesn't simply say, can we have it in electronic? And it takes us back to the fact that we are having to do hearings under pressure of time. Disclosure has been a much more prolonged process than anticipated for reasons that have been ventilated and we don't need to go over again. Affidavits have taken longer to be provided than, again, anticipated. And that was happening even before the COVID surge. And as Ms. Knock makes the point, is that will now be a factor that may introduce further delay. What that means in reality is that the time that the Commission of Inquiry has, and the team that I am part of has, in terms of getting ready for a hearing, is much reduced. And not just in terms of preparation time, but for the other matters that one needs to go through in order to be ready to have a hearing. And that is why we ask for hard copy bundles. And it means that I will have a hard copy bundle, you, Commissioner, will have a hard copy bundle. There will be hard copy bundles available for witnesses. You will have seen that there have been occasions when we have called two witnesses together. It's effectively the quid pro quo. If more time is needed to provide for example, an affidavit, then the way that comes with the request that it be given in hard copy, and that's why it was set out in the protocol as it was. We need to be able to move in a flexible manner, which is why also we have asked that redacted copies be provided if redaction is being sought, because, and it goes back to the point that Ms. Knock has made on behalf of the Attorney General. If she is going to reserve her position in relation to privilege, that again emphasises why the Commission, in order to get its work done, has to try and behave or act and proceed in as flexible a manner as possible. And so that sets out the rationale for the protocol, I hope. This takes us back to a letter that Mr. Olympitis wrote to the Commission, and it's dated the 7th of July, and it basically says this, that neither the Attorney General's chambers nor Withers, BVI, have the capacity in terms of time, personnel or equipment to deal with producing copies of bundles. And what's said is that that is because of the number of affidavits that have been sought. That a commercial photocopying outlet would charge $14,000 US. And the alternative is that for £7,000, Withers will have their London office make the copies and deliver it to the BVI's London office. The letter concludes, let me know how the Commissioner wishes to proceed. To the extent necessary, please treat this letter as an application to the Commissioner in respect of any costs as may require to be incurred. And I take that what Mr. or at least the Attorney General's point is that if she is going, and those she instructs are going to be required to provide, I think, more than one hard copy bundle, then they will charge the Commission for it.
Yes. Ms. Knock, as Mr. Rowett has said, the reason for requiring hard copies in the protocol is essentially the practical one, and that is that Mr. Rowett and the COI team do need time to prepare, and that time, because of the lateness of lodging both of documents and now affidavits, is, I mean, extremely short. And the only way that we can proceed expeditiously is to require hard copies. I understand that hard copies have been requested in at least one other commission of inquiry, but I don't know the reason it was requested in that inquiry. But certainly in this, that's the reason. And if the combined resources of Withers and the Attorney General's chambers say that they simply can't do the copying, given the time and resources they have, it's very difficult to see how the Commission of Inquiry could do that in the very limited time we have, given the lateness of lodging of evidence.
Well, I think there are two issues here, Commissioner. The first is ability to prepare, and the second is cost. Now, the first being the ability to prepare. Now, I can say as a BVI legal practitioner and somebody who is qualified as a solicitor in England and Wales, holding current practicing certificates in both jurisdictions, that it is not necessary to have hard copies of documents to be able to prepare for a hearing. Indeed, the BVI Commercial Court and the BVI High Court have been using electronic bundles, not only throughout the pandemic, but also post-Irma. We, as a jurisdiction, are used to using electronic bundles. Now, that's number one. I don't agree with your assertion that you need 5 copies of documents in order to be able to properly prepare. The second one is costs. Now, this is not a new issue. We have made it clear on numerous occasions, indeed before Mr. Olympitus's letter yesterday, that the BVI government is not prepared to fund the Commission's requirements for photocopying, and also does not have the resources to do so. It has provided 2 different ways that the Commission may wish to receive these documents. One is by use of a local firm, however, a local printing firm. However, given the sensitive nature of these documents, they do not think that that would be advisable, or also potentially using Withers London office. Now, as you may be aware, Commission, everybody on the IRU team has sworn an oath of confidentiality, and indeed, as have everybody who works for the Attorney General's chambers. If personnel in Withers London office are to provide these photocopies, they will also swear an oath of confidentiality. So it is up to the Commission. If they wish to have hard copies, they will have to pay for them. The Attorney General nor Withers will pay for these, nor will the BVI government, I'm afraid, Commissioner.
And what power have I got to pay such costs?
Well, on the Commission's website, it says that the core costs of the Commission will be borne by the UK government.
No. What power have I got to order direct these costs to be paid?
Well, you have all the powers of a judge.
Well, I have all the powers of a judge in respect of summonses, but unfortunately not all the powers of a judge. Sometimes I'd rather like to have all the powers of a judge, but I simply don't have all those powers.
Well, we're going to have to come to some sort of arrangement if you wish to have hard copies, because the BVI government is not providing you with 5 hard copies of all of the affidavits, Commissioner.
So that is a point where the Attorney General is not going to comply with the protocol.
Correct. As I mentioned before, she will not be complying with all of the protocols. We have made this position very clear in previous correspondence that it is disproportionate and costly to think that the BVI government should be providing 5 hard copies. Also, Commissioner, it is not clear, and we have asked this question before, where these 5 copies are going to go, and also what is going to happen to these 5 copies of documents after the Commission is finished. Now, part of the reason why the IRU has been instructed by the Attorney General's chambers is to ensure that all government documents are logged and before they are provided to the Commission, because the BVI government wants to know where its documents are at all times. We have asked you on numerous occasions, dating back to when we had to provide documents via email, what the security systems were in order to keep the BVI government's documents safe. And we have never had a proper answer other than to say that the Commission will keep them safe. So to provide 5 hard copies of documents again raises the security issue. Quite apart from the costs and the labour, it is simply not possible for the BVI government to provide 5 copies of all those documents unless it is outsourced to another firm, and the BVI government will not be paying those costs.
Mr. Howard, in terms of the practicalities, for this week and next week, we are fair set in terms of the evidence, as I understand it.
Yes.
In respect of statutory boards, we don't have all that evidence yet.
Yes, and we may, on Ms. Knox submissions, not get it.
Well, we
No,
may not.
that's not what I said, Mr. Rawat. I didn't say you may not get it. I said you will not get your letter by today. I did not say that you may not get all of the information that you are seeking in relation to statutory boards.
Just one moment, Ms. Knox. But we don't know when we'll get it.
We are hoping that you will get it next week, but we are doing what we can to provide you with that. We are mindful that your hearings in relation to statutory boards start a week on Monday. So we are aiming to get you that information as soon as we can, Commissioner. I've not said that you will not be getting it.
And in terms of the affidavits to date, in terms of statutory boards, how lengthy are they?
They're fairly lengthy, Commissioner.
Well, fairly length is not very precise.
Okay, well, for one of them, I believe the exhibit ran to over 1,000 pages.
So what's the practical way forward for this?
Well, I think that the position we've reached is that we are able to continue with our hearings into next week.
Certainly.
In relation to statutory boards and with respect to Ms. Knock, and I think it's better if we both do our advocacy through the Commissioner rather than engaging perhaps in a ping pong match. But the point that we have is that we have affidavits that have been received, but there are gaps in them. If those gaps need to be filled, then all that Ms. Knock can say at the moment is that a letter, the response to your request, Commissioner, that some explanation be given, which was asked for by 4 p.m. today, will not come by 4 p.m. today, it will come possibly tomorrow. In terms of further affidavits to complete the gaps, all that Ms. Knock can say is that they may come sometime next week. So the position we are in at the moment is that there is a question mark over the extent to which we can begin hearing evidence on statutory boards on the 19th of July.
No, that's certainly right, Mr. Rice. But what about the hard copy bundles?
Well, I've set out the reasons why we need them, and with respect to the Attorney General, I think Ms. Knox's submissions make my point for me, because we may be dealing with evidence that is coming in at a very late point indeed, it may be that the BVI lawyers are far more evolved than those in England and Wales. My experience has been that, and perhaps I've done more inquiries than others in this hearing, that people do routinely provide hard copies, and they do so when requested by an inquiry chair or a commissioner. Can I pick up one point though, which is that Ms. Knox's concern, which she says has not been answered by the Commission about the safety of material. There has the Commission takes great steps and has throughout taken great steps to ensure not only that the material is held safe, but it is held in such a way that makes sure that the public can understand and appreciate that the independence of the inquiry is important. And that's why, as you indicated, we could not use the DISCO system. And that's why we've asked for material to be provided in certain ways. The position that we have reached in terms of fact is that there has been one leak of information that has been provided to the Commission. That has been confirmed as not having emanated from the Commission. The other place it could have emanated from is the Governor. That has been confirmed as not emanating from the Governor. The Attorney General has been written to and is still in the process of investigating who had access to the document that was leaked to the press, and how it came to be leaked, and a reply is awaited for her. But given that Ms. Knock has made clear the efforts that the IRU go to track where material goes, it might be helpful if she can respond, perhaps not now, but in writing, to the direction that you made in relation to that leak, which was to set out, and there's a request made to the Attorney General to identify now which lawyers, which paralegals did have access to the document that was leaked. Because that's information in my submission that will provide comfort to you, Commissioner, in dealing with a matter which, as you made clear, you took with great seriousness. That will no doubt, I'm sure, if Ms. Knock cannot provide it immediately, will form part of the reply that the Attorney General will give in full shortly.
I mean, I think in respect of that point, Ms. Knock, you should liaise with the Attorney General. It will come as great comfort to the Attorney General that there is such a good tracking system as to where documents go, and it will assist her in responding to my request that I have a full list of anyone who saw the leaked document or a draft of the leaked document. So that will help. In relation to the affidavits, we have the protocol. Nobody has sought to challenge the protocol. And the protocol requires the hard copy documents in terms of evidence to be lodged. You say that the BVI courts are electronic, but certainly here within the Commission of Inquiry, certainly most of the witnesses have asked for hard copy documents. Very rarely have they not. We sometimes have more than one witness giving evidence at the same time. Because of COVID, they have to have their own bundles of documents. Now, of course, they'll be remote. And certainly, Mr. Rawat and I work from paper documents. What I would, so there's nothing further for me to say. We have the protocol, and the Attorney General and those she represents as participants are bound by the protocol. But I would say this, Ms. Knock, what I am most urgently concerned with is the work which the Commission of Inquiry that I wish to do over the next 2 or 3 weeks. I've identified what that work is. After next week, it will be statutory boards, and after that, it will be Crown land. And it's those affidavits that we will need in hard copy to enable those hearings to proceed.
Commissioner, I think we've made the Attorney General's position. I think I've made the Attorney General's position clear. The Commission will not be provided with 5 hard copies of the affidavits and the exhibits.
Well, I've made my position clear, Ms. Knock. The protocols are there. Participants are required to comply with the protocols. I've identified exactly why we need the hard copies. I've identified in particular the affidavits that we need to have hard copies of to proceed with our work in an efficient way.
And we have provided you with alternatives. If the Commission will fund the cost of providing those documents, 5 hard copies, then they will be provided. Otherwise, they will not be provided. And at the moment, they cannot be provided because the offices are shut, Commissioner. There is nobody to physically copy them, even if we were going to.
Well, the protocol is there. We have a couple of weeks to work out a practical solution. I wish these hearings to proceed in an efficient way. As you'll appreciate, the documents you're providing are not all of the documents that we're having to produce for hearings. They're only the evidence upon which the Attorney General, the IRU, is producing. That's all it is. It's a fraction of the documents that we have to produce. And so the protocols are there, and I've indicated that in respect of those 2 topics, I wish those protocols to be complied with.
May I suggest that the Commission considers using electronic bundles, because as I've mentioned before, people in the BVI are very used to using electronic bundles in hearings.
Well, as I say, our witnesses are prefer hard copies, and I understand that. And at the moment, we are using hard copies. Anything else, Mr. Rowett, from the list?
No, can I just, there's one final matter, which is related to some recent disclosures made, and that's this relation to assertion of a claim for privilege. Now, Commissioner, you indicated earlier that this matter would need to be heard in a private hearing.
Yes.
The letter of today moves it a little bit forward. I'd suggest that if all parties take this approach, and that is not to refer either to the detail in that letter or to the detail in the document itself, then we
needn't go into
private session. And we have also the 3-minute delay in any event if anybody wants to object. The position that we've reached, as I understand the letter, is that on the particular document in which on which privilege was asserted, what's said is that the Attorney General would be willing to waive the claim for privilege. But what then follows is a condition that is attached to it, beginning with the word "so long" in the letter. With respect again to Mr. Olimpitis, it's not a good point to say that privilege will be waived on the basis of a particular condition being imposed as to the use of the document. Either privilege is waived or it is not. I don't think that there is a proper basis on which conditions can be imposed, and it has practical consequences, because if the document is then put to a witness, they might not feel bound by the same condition. And so I think that the decision, or what for the Attorney General, no doubt acting on instruction because it's not her privilege to waive, the decision or clarification that needs to be sought from Ms. Knock is whether the document privilege is waived or whether it's not.
Well, I think that Mr. Olimpitis in his letter made it very clear the Attorney General is willing to waive privilege on that particular document, so long as it is put into context.
But the context is evidential. How can the Attorney General give that evidence?
I'm not sure I can add anything more to without talking about the document itself. I'm not sure I can add anything more to what Mr. Olimpitis had discussed this via correspondence than we certainly can. But right now, either privilege is maintained or privilege is not maintained with that condition. There's nothing more I can say, Commissioner. If you would like to continue this discussion offline and via correspondence, then we can, but that is the position. Those are my instructions. I can't add anything more.
Let's see. Are you saying that you want to go into private session to discuss this?
No, I'm not saying I want to go into private session to discuss this, Commissioner. I am saying that our position was put in that letter. There is nothing more to say.
Do you accept that the condition is evidential?
In what respect, Commissioner?
Well, it's giving evidence. The context that's set out there is a matter of evidence.
Commissioner, I am not prepared to discuss this privilege any further, either in a public hearing or not in a public hearing. We have made our position clear. I am not discussing it any further.
But it's not clear, that's the trouble.
But it is clear. And I'm not discussing it any further at this stage.
Well, it's not clear to me, I'm afraid, Ms. Knock. And one of the purposes of this hearing is to determine whether privilege is waived or not.
Well, I can go away and I can seek further instructions, Commissioner, but at this point in time, I cannot discuss this any further. We have made our point, and that is how it's going to be. I can go away, I can seek instructions, but right now I have nothing further to say on this point.
I mean,
I think the position we've reached is that Ms. Knox's instructions are limited to what is set out in the letter of today's date from Mr. Olympitis.
and she can't go further.
And she has no further instructions on the point. So all that we can ask her to do is to take further instructions as to the basis on which the Attorney General would be willing to waive the claim for privilege. In taking the instructions, you might be assisted by some clarification as to who is actually asserting the privilege, the basis on which it's being asserted as well. But other than that, I don't think, in light of what Ms. Knock has just said, the matter can be taken any further.
In respect of the hearings next week, I'd like to deal with this at a hearing. It should be dealt with at hearing, and it can be dealt with in a private hearing if that's what the Attorney General wants. What I'd like is somebody with full instructions on behalf of the attorney to be able to make submissions to me. When next week would that best be done?
We have the timetable will be dealing with legal submissions next week on the 13th of July. We haven't yet published that, but we have written both to the participants inviting legal submissions on specific matters.
And that's at 9:30 on Tuesday.
Yes. So
Okay.
If
We'll
not can take instructions by that time, we can revisit the matter on.
Yes.
On
So,
that time.
so Ms. Knock, this part of the directions hearing, I'll simply adjourn over until 9:30 next Tuesday. It'll all be remote in any event, but then we do need somebody with instructions from the Attorney General to explain the privilege that's claimed, if indeed it's still claimed, and to explain the condition if the condition's maintained.
Okay.
Good, thank you very
Understood.
much. Is that anything else?
I think
Mr.
that
Howard?
concludes all the matters that we need to deal with. I don't have anything further to raise.
Good. Mr. Fickleston-Davies, anything to add?
No, Mr. Commissioner. I think I don't think there's anything I can add to.
Good. Thank you very much, Mr. Davies. I'll rise because we have further evidence this afternoon. I'll rise now while we just reconstitute ourselves. Good. Thank you very much. Good. Dr. Glasgow, can you hear and see? Can you hear and see us?
Yes, Commissioner.
Good, and we can hear and see you. Thank you very much, Mr. Rawat.
Dr. Glasgow, I hope you can hear me as well.
I can hear you.
Thank you very much for making yourself available to give evidence today. I understand that you would like to affirm, is that right?
Yes, that's correct.
And you have the words of the affirmation with you?
Yes, I do.
Would you read out the affirmation now, please?
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you. Can I just check what you have with you? Do you have a copy of the affidavit that you've provided to the Commission?
Yes, I do.
And together with the exhibits as well?
Yes.
What I'll try and do in putting questions to you is stick to the exhibits, but it may be that we might need to go to what we've marked as the Constitution and Legislation bundle. Do you have a copy of that?
Yes, I have a copy.
Thank you very much. I'll try, and this is something I say to all witnesses, to keep my questions short and simple, but if at any time I ask a question that you find difficult to understand, please do stop me and I'll try and repeat it or rephrase it, all right?
Sure.
Thank you. Can I also ask that you keep your voice up so that the stenographer can hear you clearly so we can have an accurate record of your evidence?
Sure.
The other thing that we both will need to try and do is not to speak over each other. I'm probably more guilty of that than you will be, but if we both keep that in mind, it should be easier going forward. Dr. Glasgow, you have in your affidavit identified your current role as being Director of Projects of the Ministry of Finance. Before we turn to what that involves, could you just give the Commissioner an outline of your professional background before you were appointed to that role?
Sure. So I'm trained as a civil engineer, having completed a Bachelor in Civil Engineering at the Florida A&M University, followed by a Master of Science and Doctor of Philosophy at the University of Minnesota. I do have a professional engineering license that I operate under. I joined the public service in 2003 for a short stint for about 4 months at the Vehicle Licensing Department as a Chief Licensing Officer. During that transitional period, or after that transitional period, after that 4 months, I was the Deputy Director for Public Works Department, and I served in that capacity until 2007, to which I acted as Director for Public Works until 2012. In 2012, I joined the Ministry of, at the time, Communications and Works. That's now Ministry of Transportation, Works and Utilities, as the Chief of Infrastructure, Planning, Research and Development. Stayed there for 2 years, and I'm now in my current position, being the Director of Projects, which I started in February of 2014.
I think you've given the date as your start date is the 17th of February 2014.
That's correct.
And could you just explain to Commissioner what the role of Director of Projects involves?
Yeah, sure. And so as Director of Projects, I am the lead personnel on capital projects and technical matters to advise the government. In that role, I guide the development of project management, project development, risk management, quality standards, etc., for the execution of infrastructure projects funded by the government and also sponsored by government. I facilitate the preparation of the capital expenditure program for the government on behalf of the Ministry of Finance. We do have a monitoring role in the unit, that's the projects unit that I serve with. to monitor the delivery of capital expenditure programs from different ministries. So somewhat of a vetting role. And then there's also the role of project budgeting to ensure from a policy perspective, a financial perspective, that projects are delivered with key value for money, transparency in a transparent manner, fair, and also for the benefit of the government of the people of the Virgin Islands. Those are the primary roles. Of course, there are ancillary roles, assisting in decision making, advising the financial secretary in those matters, dealing with cabinet, the matters of cabinet, and again, an advisory role. Over the years, I have taken keen interest in procurement, being trained and having taken quite a few courses and undertakings related to procurement, the procurement of projects through loans and other funding agencies. So in brief, not so brief, that's what I do for Government of the Virgin Islands.
You mentioned the projects unit. The Commissioner has heard evidence of that there was a project management unit in the Ministry of Finance, and certainly that was in existence around 2014, 2015. Is that the same unit that you're part of?
Yes, so the correct name is not project management unit. The correct name is projects unit. The projects unit is comprised of two different components. Project services support unit. So that's where you have your project management that deals with projects once they've been procured. And also the procurement unit, which is involved in assisting the Central Tenders Board in the procurement of projects that we call major projects, projects that are valued over 100,000 US dollars.
I've also, as you've explained that its proper name is the projects unit, and has it always been the projects unit?
No, prior to that, it was simply project support services unit. And prior to that, it was called I think the name was project cycle management unit. That's way before my time.
Can you, you say it's way before your time. Can you give the Commissioner an idea of when that unit was first established?
I do not know that.
When you joined it in 2015, was it already an established unit within the Ministry of Finance?
Yes, when I joined in 2014, that is.
Sorry.
It was called a Project Support Services Unit. So the name had already changed. And so once I joined, not too long after, it was called the Projects Unit.
Thank you very much for that. Can I just turn to your affidavit itself and just take you to paragraph 3 of that affidavit, please? That says at the outset, I should further say that in this affidavit, where I mention a document, I do not waive any privilege asserted in respect of it unless I do so expressly. Now, you have, and this is, you'll see this at paragraph 5, you have an exhibit to your affidavit which contains a number of documents. Which of those documents, if any, are you asserting privilege over, Dr. Glasgow?
And let me just ensure that I have the correct understanding. Asserting privilege mean I do take ownership of that?
Well, it's just in your affidavit that there is, if you look at paragraph 3 of your affidavit,
yes,
it says that you do not waive any privilege asserted in respect of a document unless you do so expressly.
In respect of that, Dr. Glasgow, what did you mean by that? That's probably the starting point.
Yes, so the information that's provided in those documents, they are provided noting that I am not the author of those documents, but I do recognize the contents of the document as being authored by the particular persons or the entity that are noted. And so my evidence provided has that in mind.
Was it your decision to put that paragraph into the affidavit, or did you do it on advice?
This is on advice.
And did you understand what was meant by privilege when you put that into your affidavit?
I understood it to mean, unless I have said that the contents of those documents that I've placed in there, unless I've said that they are not applicable to this particular affidavit, or I cannot attest to it with the ownership of the documents or the author of the documents, that I do not waive any rights or any assertion that I make from the document or privileges that's pertain to the document. That's what I understood from it. I'm not sure if that's the correct understanding, but that's what I understand.
So you understood it really as protecting other people's intellectual property rights?
Well, protecting, that's one part of it. And the other part is protecting me, that it was not authored by me.
Yes. So you acknowledge that other people have authored these documents and not you?
That's correct.
No, thank you very much.
What I hope that we will be able to get your assistance on today, however, is just essentially the law and practice in relation to the procurement of government contracts in the Virgin Islands, which is something that you have set out some details in that affidavit. And I think, as you indicated earlier, procurement is something in which you have an understanding and an interest. Is that right?
That's correct.
If we could just take it, first of all, just I'd suggest we take it in a particular order, and we deal first of all with purchase orders and what is meant by purchase orders. You have dealt with that in your affidavit at paragraph 8, and you refer there to section 172 of the Public Finance Management Regulations of 2005. If you look in your own exhibits at page 62, and the numbering is in the top right-hand corner.
If you just give me a moment.
Of course.
I am working from electronic copies, so. Did you say 62?
Yes.
Okay, I'm there.
In paragraph 8, you refer to a purchase order as being the most widely used instrument, and you refer to it as being used in relation to works or services. If we look at 172, that refers to using a purchase order for the supply of goods. Is it your understanding that in the BVI, or the BVI government uses a purchase order to buy both goods and services?
We use purchase orders for goods, services, and works.
And if I've understood 172 right, you can, if we look at 172.1, you can use a purchase order for up to $75,000. Is that right?
Well, you can use a purchase order. When you say use a purchase order, you mean to actually contract with a contractor or supplier or vendor?
You've you've said that a purchase order can be used to buy goods, services, and works.
Okay.
If we cross-relate that to 172, that sets out the limits that a purchase order can be used. And at different limits, you need different types of authority.
Correct.
But the top limit seems to be $75,000. If we look at 172 1C.
Correct.
So does it follow that whether you're buying goods, services, or works, you could use a purchase order for up to $75,000?
That is not the correct interpretation. Before I continue to so 172, I think it was in the amendment of, I believe it was 2007. There's an amendment that's as a part of that revised those numbers. So where you had 50,000, it went to 75. Where you had 75, it went to 100,000. So I just wanted to make that. But the distinction.
Sorry to interrupt you, Dr. Glasgow, but I think you mentioned the amendment of 2007. That's at page 98 in your bundle.
Okay. Yes. So if you look at subsection A, so 172 1A, it speaks to purchase orders only for purchases that do not exceed $10,000. So this is correct. And if you link it back to my affidavit speaks directly to purchases. If there's purchases that are valued less than 10,000, then what I'm saying is a purchase order is sufficient. Once once the value goes above 10,000, then it triggers, as you mentioned rightfully, another set of approval. And so that's where we get into our petty contracts and our major contracts. But below $10,000, it's a purchase order is sufficient to contract with a vendor.
I think if just to clarify it, if you look at 98, at the amendments that were made in 2007, you're right to say that Regulation 172 was amended, but it wasn't amended in terms of the figures.
Yes, I do know that. I do know that. And I believe what we actually see there, the intention, I believe you perhaps would have to have a even more word with the Attorney General, but the intention was for all the numbers to be revised in that matter. And I'm aware that there was one section that was revised, and the portion in 172 remained at the same numbers. I think that correction was made. It was identified and made, but I think the intent of the corrections or the update to 172 or to change or revise the figures was to ensure that all numbers within the legislation or the regulations were amended. But you are correct in noting that the amendment did not address on paper 172.
Dr. Glasgow, can I just refer you up the page on page 62? I mean, you'll know these regulations very well, but at the top of page 62, there is Regulation 170, paragraph 2, which says that goods and services shall be procured by tender where the value of the goods or services exceeds $75,000, unless the Executive Council, now the Cabinet, of course, otherwise directs. So it seems to me, looking at page 62, that Regulation 170, paragraph 2, sits well with Regulation 172, because over $75,000, you have to have a tender process, subject to Cabinet waiver. And then Regulation 172 in respect of at least goods tells you the approvals you need up to $175,000. Is that right?
Yeah, your assertion is right. But again, the the intent of the amendment was to ensure that everything in the legislation, sorry, the regulations that noted, that noted 75,000 should have moved to 100,000. So as you have rightfully mentioned, 170 section 2 speaks to 75,000, which follows into 172 part C, that also speaks to 75,000.
Yes.
So what I'm asserting is the intent of the regulation amendments of 2007. The intent was to change wherever you saw 75,000 to 100,000. And so
I'm sorry, carry on, Dr. Glasgow.
yes, so as I mentioned, that seemingly was not carried through in the entire regulations, and that was noted. And I believe it was seen and observed, and a rightful change that was made. And I believe that was done in the 2020 amendments.
So I think that's right, but I think that's right. I think 2020 made those amendments. But until 2020, what the regulations said, and I understand what you say was the intent, neither Regulation 170 paragraph 2 nor Regulation 172 were in fact changed to $100,000 in the 2007 regulations.
That observation is correct.
Yes. No, thank you very much.
Although, if we look at 172, if you had the approval of the financial secretary, you could issue a purchase order up to $75,000. Is it your evidence that in practice, purchase orders are used for transactions that are up to $10,000?
Up to $10,000, yes.
If the transaction was to go beyond 10,000, would you expect then to be seeing a petty contract in place?
That's correct.
Could we just look at works orders, please, which you also deal with, and that's in paragraph 7 and 8 of your affidavit. But if you turn to page 69, your exhibits,
okay, I'm there.
That's where you have directed the Commissioner's attention to Regulation 189.1, which explains that a contract for work or a service not exceeding $10,000 in value may be entered into without the execution of a specific contract document by a works order. And as you point out in your affidavit, Dr. Glasgow, that's a discretionary, it's an optional instrument. It's not mandatory at all.
Correct.
What you have said though, and this is at paragraph 7 of your affidavit, if you have it, works orders are typically used where the works can be clearly defined and they allow the supervising ministry to manage the progress of the works that have been agreed with the contractor. This offers ministries a degree of leverage in keeping the contractor to account based on the agreed responsibilities and scope. I just wanted to ask you this: how are the agreed responsibilities and scope recorded if you don't have and are not required to have a specific contract document?
Okay, typically works order lists the scope that the contractor is required. If there's any technical work involved, of course there can be an attachment of conditions or specifications, but suffice to say the scope is included in a very, and they're usually very self-explanatory. You do this, you do that, this should be done this way, and specifications, everything is produced there. And so the contractor actually signs this document. So it's somewhat of a contract, though it's not a requirement. It's government's way to say, you know, we can keep the contractor to account based on what they have signed and agreed to.
And so does it follow that the works orders can, in certain circumstances, go into quite a lot of detail as to what's expected of the contractor?
That's correct. It has the potential to do that.
Just to help me with the practice of procurement, the Regulation 189 works orders refers to a contract for work or a service. Regulation 172 refers to a tender or contract for the supply of goods. Now, you told us that Regulation 172 is in fact used for goods or services or small
works and services.
Yes, exactly. Goods, works, and services. On the face of it, it looks as though Regulation 172 might be restricted to goods, and Regulation 189 not to goods but to work and services. How is that dealt with in practice, Dr. Glasgow?
Well, when I said, of course, that 172 applies to works, goods, and services, what we have done in practice is to ensure that we use, what should I say, a level of accountability by ensuring that whatever is done for goods and services, that's at minimum, is also seen in works. Now, while 189 speaks to works orders, which are not necessarily mandated, both goods, works, and services, they all require a purchase order. So even though I have a works order, I still require a local purchase order to make that effective. That's government system, and that's government's mechanism within its accounting system to say that a contractor legally has a binding agreement. So no funding, no payments can be made unless a purchase order is in place. So when I say we also use 172 for works, it's simply for that safeguard as well. So once we are below $10,000, we accept purchase orders. So 189 also allows for purchase orders, but the trigger is above 10,000. So we think that it's quite conservative, and it shows accountability across the board that all three, whether you're dealing with works, goods, or services, whether or not the regulation specifically says works are involved in 172, we find that it's more transparent and accountable to ensure that this goes across the board. Now, I mean, if you read through the particular regulations, I think we can all agree that it is lacking in terms of doing procurement and actually making sure that we have procurement across the board in a manner that's best practice. And so we recognize, of course, the deficiencies within here. And so for some time, you perhaps would get to it a little later, we have been through doing some procurement reform to correct these type of anomalies.
I think Mr. Rowett may well come on to that, I think, but
yes,
just to confirm, because I think what you said is very clear. But if there's a contract for works or a service of less than £10,000, you have to comply with Regulation 189, but you also have to comply with Regulation 172 because you need a purchase order as well. Because I think, to put it bluntly, without the purchase order, you won't actually be paid.
That's correct. Yes.
No, thank you very much.
Before we leave 189, could you, Dr. Glasgow, please just take a look at 189.2? Oh, sorry, 189 subparagraph 2. which relates to 2 or more works orders shall not be used for the same works or services. Would the correct interpretation of that mean that you cannot use multiple work orders for the same works or for the same service?
For the, yeah, I think that's very ambiguous, because it doesn't really define what same works or services mean. And I'll tell you why I say that. Are we saying that if I'm to just pick some type of work, I'm supposed to clean this particular window? Is it saying that more than one work order should not be issued to clean this same window? And of course, the opposite side of the spectrum is when we say works or services, are we speaking about projects, to say that not more than one work order can be issued against a particular project, no matter the size? So I think there's a bit of ambiguity there. So I would hate to say, or I cannot say what the intent of this was, but it's not very clear.
But in terms of that, the works or services, aren't they the works or services? So if you had to build, a small shed or something, building the small shed, that's the works. And doesn't it mean you can't have 2 or more works orders to build the shed? So if the shed, for example, cost more than $10,000, you couldn't have 2 works orders sent to the same man for $10,000 and $5,000 to build the shed, or does it mean something else?
Did you say to the same person?
Well, yes, or different people, but
yeah.
to the same person or different people.
Okay, I would interpret it that way as well.
Yes. Okay. Thank you very much.
And it's a convenient time to deal with it. You suggested, Dr. Glasgow, that that particular subsection is open to ambiguity. Have any steps been taken that you are aware of to resolve that ambiguity?
Oh yes, I'm glad you asked that question. Because as I said, you probably would talk about it. We probably will speak about it a little later, but we have been in for some years, procurement reform, and we are proud to say that we do have a standalone procurement act and regulations that addresses all of these issues. So I'm not sure if you want to speak about that now, or we can wait a little later.
Well, I think it's because we're on the question of how work orders operate in practice. It's a good opportunity for you to speak about work orders, and it's because you've said, actually, your reading of it, you suggest it might be open to interpretation. What is in terms of the reforms that you speak of, what changes are going to be made in relation to the use of work orders?
Well, if my memory serves me correct, I don't even believe that we mention works orders in the new act and regulations. We simply speak of the threshold and what's required.
But in terms of, because if we take the Commissioner's shed analogy, if you have a shed that's got to be built for 15,000, which requires, under the legislation that we're looking at, a petty contract, on one reading, if you read 1892 to allow you as a ministry to use works orders to get round the need for a petty contract, you could issue the same man or 2 different people with a work order for 10,000 and a work order for 5,000. And a different interpretation of 1892 is that you can't do that. Under the new regime, I appreciate that you are, you say it's about thresholds, but will the new regime avoid using or using sort of multiple orders as a way of getting around thresholds?
I would have to say yes. And if I would even to go back, right now, the scenario that you speak to, I know the Ministry of Finance is, the financial secretary, this is not something that's supported. It's something that's very difficult to sell. Definitely there are situations that may warrant something like this, but it's far in between. It's far from being the norm. And so I know within the Ministry of Finance, this is a flag, and they would take to task and require a full explanation of what's going on with something like that. But the new regulation, as I mentioned, the new suite of regulations, they provide for the contracting or the procurement of works and services and goods in the form of the type of procurement to be used. And so based on the thresholds, you can of course invite, you can have open tenders, etc. But it does not say we're just gonna issue. If we're gonna issue a purchase order to a sole vendor without a competitive process, there are reasons that's stipulated within the regulations for when you can actually do that. And again, it's not the norm. So I would say that it has addressed this issue.
Can we turn to petty contracts, please?
Sure.
Which you deal with at paragraph 9 of the affidavit. And the point you make at that paragraph is that petty contracts are used to cover the procurement of goods, services and works, but that there is actually no provision in the 2005 regulations that specifically define petty contracts.
That's correct. That's just a name that we use locally.
It's a term of art that's been established for a long time in the BVI.
Correct.
Can you, as a term of art and as a term that's used locally, how long has it been in use?
Well, I joined the service in 2003, and so I met the term being used as that. I'm not sure of the history behind the term petty contract, but I have met it in place.
And it would seem that the understanding in terms of the public service, certainly after 2007, on what you said earlier, Dr. Glasgow, was that petty contracts, the range for petty contracts was between $10,000 to $100,000.
That's correct.
And that's how ministries operated in practice, on that understanding.
Yes.
But I'm sorry to interrupt, Mr. Rowett. I think probably, is it more accurate to say that, I mean, we know what a major contract is. I'm not sure that the term major contract appears in the regulations, but we know what a major contract is. It's a contract over $75,000 or $100,000, this limit. And above that, it's a major contract, and it's subject to various procurement, a procurement process, subject to waiver by the cabinet, but it's subject to a particular procurement process. A contract under that threshold is not subject to that procurement process. It's subject to a different procurement process, which is also set out in the regulations. And I mean, but for something under $10,000, as I understand it,
you can.
You don't have to, because you can have a works order and a purchase order, but you can. It's just above and below these levels, different procurement processes apply.
And that's correct.
Yes, thank you very much.
But just to take you back to thresholds, we were looking at 1702 earlier, which is at your page 62.
I'm there.
And that's the provision that says that once you get above $75,000, you'd have to go to a tender process. And when we, if you look at 66, okay. I'm taking you to 181, which was amended by the 2007 regulations. So the figures that we see there, where you see in D, that it's where the contract sum exceeds $50,000 and up to $75,000, that was amended by the 2007 regulations to read $100,000. And that would seem to be the provision that gives you the range, that once you get above $100,000, you're in major contract territory. But it's not easy to reconcile, is it, with 170?
In terms of the threshold that's written in 170?
Yes, 170 gives you a threshold of $75,000 as the point where above which you have to go to tender. But 181 seems to, with the amendment, seems to suggest that you can operate without a tender up to $100,000.
Yes, this is the anomaly that I spoke of earlier, where the intent of the amendment in 2007 was to get rid of everything that said 75,000 and amend it to 100,000. So that's why there seems to be that conflict between the two.
But that's absolutely right, Dr. Glasgow. And then that conflict was resolved in the 2020 regulations.
That's
because
correct.
The 2020 regulations does make everything $100,000.
That's correct.
Yes, thank you.
Which just means that although the practice of having a range of up to $100,000 for a petty contract may not have been one that was right in law, because the change to 170 hadn't in fact been put into effect. The intention was there, but the change didn't follow through.
You are correct in saying that the change didn't follow through. Of course, whatever minutes from meetings in cabinet, et cetera, that authorized that change, I wouldn't have known, but it was announced. It was whatever workshop and informing the public, informing the entire public service that the thresholds have now moved from 75,000 to 100. Even without, and even for myself looking through this, it wasn't until very recently then that I actually looked at it and saw that it was that particular section did not have the benefit of the amendment to 100,000. But as you said, the practice has been, the thresholds in practice were 10,000 and 100,000. And I remember when it was changed back in 2007. So again, that's the premise behind of all of this. And as you can see, there's a clear conflict there. But at face value, the change was not made in the regulations at that time.
But what your evidence is, and it's from direct experience, because you were, as you said, in the public service from 2003, the intent was made known to all.
That's
and
correct.
The public service then proceeded on the basis, they adopted the practice of the threshold of 100,000.
That's correct.
Can I ask now about major contracts, please? And that's paragraph 11 of your affidavit. And again, you've explained there that it's a local term, that if you go over 100,000, you're referring to a major contract. Now, you refer there to the procurement process, and you've identified the financial secretary, yourself as director of projects, or the procurement coordinator as individuals that a request would be made to. What's the role of the procurement coordinator?
If you remember my my initial statements, concerning the projects unit. The projects unit has two components: the project support services and the procurement unit. The procurement unit deals with procurement of works above 100,000. By the regulations, they are actually the secretariat to the Central Tenders Board. So once a project is expected to be in excess of 100,000, a request is made to the procurement unit, or if it comes to the financial secretary, if it comes to myself, it's then passed on to the procurement unit, who, again, they the trigger know exactly what they have to do to get a tender published and receive tenders, etc. So that's the role of the procurement coordinator. They basically act as a secretariat to the Central Tenders Board.
And if we look at 173, which is at page 63 of your exhibits, Dr. Glasgow. That's in effect what 173 through to 177 is, at least in the regulations, the tender process, isn't it?
Just browsing through it here, yes, it would appear so. Yes.
It may just be one thing I've noticed on your exhibits, and this is a good example. And particularly if you look at 174 and 174.3, there is wording that has been added in red. Do you have that on your
yes.
Would you be able to just help with where that wording emanated from?
To be very honest, I have absolutely no idea. It would appear to me, this is the actual document itself. So you would actually find this wording within the document that was approved back then. It's in red on my document. I really do not know why, but these perhaps represent the changes that were made at that specific time.
I would agree with you there, but I also share your lack of knowledge, Dr. Glasgow, because it doesn't appear to, the wording wasn't introduced in 2007 or 2020. So it may have been, as you point out, wording that was introduced at the time that the regulations were promulgated, so 2005. In terms of the Central Tender Board, is that in place?
Could you, when you say in place, you mean the 173 or?
If you look at 174, that tells us there shall be a Central Tenders Board.
Okay.
And it then gives the membership of the Central Tenders Board. Currently, is there a Central Tenders Board?
Yes, that's correct. And it's constituted as written in section 2.
And how long has the board been in place? As far as you know, I mean, taking your time in the service, have there ever been periods when there hasn't been a Central Tenders Board?
I do not know of a period when there was not a Central Tenders Board. As a matter of fact, I think it was called Public Tenders Committee before the Central Tenders Board. But there has always been an entity that facilitated public tenders. And since I've been around, it has always been constituted in the format that you see there in paragraph 174, section 2.
And all tenders have to go through the Central Tenders Board, I take it?
That's correct.
If you look, please, at 65 now. At the bottom of your page 65, we find section or regulation 180, which says that a copy of each contract document shall be sent by the accounting officer to the accountant general and the auditor general. What sort of contract documents is that referring to in practice?
The contract itself, assign the contract.
Is that just the tender contract?
No, the contract between the government of the Virgin Islands and the contractor or the vendor.
I phrased my question badly, Dr. Glasgow, I'm sorry, but does it just apply to major contracts?
I remember a time when it was focused on major contracts, but in recent years, and I know some ministries continue to do it, all contracts, to my knowledge, since I was at Public Works, have been going to I know it has 7 different entities. Accountant General, for sure, no payment will be done unless you produce a contract to them, and also the Auditor General. As far as I can remember, these are 2 of the 7, I think it's 7 places that contracts go.
And is there a threshold below which contracts don't go?
No, I'm not aware of a threshold. As I said, especially for aid Accountant General, no monies will be paid on a contract unless they have the contract.
And does that apply to the works orders as well?
That's correct. Everything. So the Accountant General will require you to see all the supporting documents that goes with the payment, including if it's a purchase order, a loan, if the purchase order is accompanied by a works order, if it's accompanied by an invoice, in cases where it's actually works done, pictures. So payments will not be made unless those things are in place.
And if you look, please, at 66. And Regulation 184, which deals with advance payment. What Regulation 184 prohibits advance payment on a contract without the approval of the Financial Secretary. What kind of contracts does Regulation 184 apply to in practice?
In practice, petty contracts. So anything that's below 100,000.
But above 100,000.
I would say it does not apply because above 100,000, the contract document actually makes provisions for an advance payment. So the conditions of contract speaks to an advance payment of a certain amount. And this is what's tendered. The contractors or the bidders respond to bids in light of this actual fact. And once it's signed by the Minister of Finance, once the contract is signed, you have a signed contract agreement, that advance payment kicks in. So there's actually provisions in the contract that takes care of this clause.
But below the petty contract threshold, any contract of any size, including a work order, for example, if you wanted to make advance payment, you'd have to get the approval of the Financial Secretary.
That's correct.
Could you turn to page 68 in that bundle, please? And it's just the reference to a contract register and Regulation 188. That sets out the details of a contract that should be recorded in a contract register. But again, in practice, Dr. Glasgow, what type of contracts does Regulation 188 apply to?
All contracts. In practice, all contracts. So whether it be petty, major, purchase orders, each accounting officer is required to have this this type of information. Clearly below, if it's a purchase order, of course you won't have a contract number. So I would say once there's a signed contract agreement, it triggers, and ministries, these are kept within the ministry. Every now and again, the Ministry of Finance would ask ministries to produce them, definitely from the projects unit, because we want to ensure that we cross-reference our records with their records.
But in effect, no matter how small the contract size, what there has to be is within each ministry a central register of the contracts.
That's correct.
You have, and I'll take you, if I take you to paragraph 13 of your David, you turn there to the discretion that Cabinet has to waive the tender process. And it can be sought for goods, services, and works. And you give examples at paragraph 13 of circumstances in which a waiver may be necessary or may be sought. Is there, aside from those circumstances or those examples you give, but is there actually any written guidance or policy as to how Cabinet should approach waiving the tender process?
Actually, no, there's nothing on the books currently, and of course, we have, as I mentioned already, we have flagged things like these type of what we would call deficiencies or anomalies. We have flagged them because we have gone through an assessments, at least 2 full assessments of the procurement system. We have flagged this as a red flag, and with the new regulations, the new act, as a matter of fact, addresses the point of waivers, and so it would have been the most the proper thing, or the most logical thing we should have been focusing on is, of course, defining when those waivers actually should be come into force. Because if you look at procurement legislation throughout the world, there are points where you will require a tender waiver. But what we're saying is, or what I'm saying is, it just can't be unregulated. And so we've ensured that the new act and the new act, by the way, has been passed by the Cabinet. It's just awaiting its first reading in the House. But the act addresses the point of waivers where, unless for these specific reasons, you may not, or you may waive the tender process only on account of these specific reasons.
And is the intent behind that part of the new act to reinforce that waiver of tenders should be the exception rather than the norm?
I would say that, yes.
And
I'm sorry, Sarah. This was dealt with at least partly in the 2020 regulations, which replaced Regulation 170. Well, it replaced Regulation 170, paragraph 2, and replaced it with 2 paragraphs, one dealing with waiver. Have you got that, Dr. Glass? You probably know it well anyway. It's Regulation 2 of 2020.
Page 101 of your bundle.
Yes, it is.
(101). I feel like I'm hopping like a bunny here. I'll be there. 101.
Which inserts a new Regulation 170, paragraph 3.
Okay, I'm there.
And that sets out 3 circumstances in which tenders can be waived. The last one being any other exceptional circumstances. The other 2, obviously, in part driven by the COVID pandemic, one would have thought, together with the procurement of such goods or services by way of the tender process would, in the determination of Cabinet, be inimical to the public interest if such goods or services are procured. So that's the current position, in fact.
Yes, and so of course it kicks in at what's defined there in 3A, B, and well C. But definitely A and B
Yes.
as it relates to disasters, emergencies, etc.
Yes. Thank you.
Could I just ask you for your help in relation to contractors? You've been given a copy of the, or at least electronically, of the Commission's Constitution and Legislation bundle.
Correct.
If you go to towards the end of that, to page 646, please, or 645.
Okay, I'm there.
And then if you go to section 3, which is on 646. That's that notwithstanding the provisions of any other act, no person shall engage in a business, profession, or trade as set out in the first schedule or otherwise, without first having obtained a license for that purpose. I can take you to the first schedule if you want to see it, Dr. Glasgow, but it includes a long list of professions and different categories of work, including construction contractor, carpenters, draftsmen, electricians, and plumbers. Now, that seems to be the statutory requirement for the need of a trade license. Before a contract, or is it a requirement that if you are going to contract with government, even at the level of a works order, then as a contractor, you need to have a trade license?
The practice is once you're going to do a contract, sign the contract, you need a trade license. So the practice has for those works, goods or services, but let's use works as an example, that's above $10,000, you require a trade license.
So if you're doing works below $10,000, do you require a trade license?
That's not the practice.
Well, do you know whether you are required to have a trade license in law?
If I refer to the section that you have sent me, shall not engage in a business, profession, or trade as set out without having a particular license for that purpose. I suppose this gives the backdrop for that. But when I read this, of course, it tells me if I go, for example, if I go and somebody has asked me to, I don't know, cut the bush in their yard, and this is on a private basis, I don't believe the intent of this says that I need to have a trade license before I can offer petty services to someone. So with that backdrop, I know the practice has been once you're gonna sign a contract with the government of the Virgin Islands, it requires you to have a trade license in place. That has been the practice.
I mean, I take your point about you know, cutting a bush on a private basis, but that's a little different from, for example, cutting the bushes on at a school or in outside a government building under an agreement with the government. Section 3, I'd suggest to you, makes clear that if you are going to engage in any profession or trade or business, you need to have a trade license. If we bring that to the application of practice in relation to engaging with government, and we'll use your example that you gave earlier of cleaning windows. If government contracts with a window cleaner for $9,999 under a works order to clean windows, is that person required to have a trade license?
The practice is no.
So they're not asked if they have a trade license?
That's correct.
In fact, the contract was for $10,001. Would they then be asked to produce a trade license?
For sure they will.
And so in terms of having a trade license, in practice, the threshold that is used is the petty contract threshold.
Yes, 10,000 and above. That's the trigger.
Now, are there any other requirements that a contractor must fulfill in order to enter into a contract with government?
Yes, there are some statutory obligations. They have to produce a certificate of good standing for Inland Revenue, Social Security. Of recent times, the NHI as well. If the contractor is a company, it requires the official company registration license, a good standing certificate from Financial Services, company registry. Those are the statutory obligations. So I believe, if my memory serves me correct, those are the requirements. I mean, and not speaking to the need to have in place maybe a schedule, etc., but the statutory requirements, that's what are required.
Are they required for, again, for all contracts or only contracts over $10,000?
Over $10,000.
Yes, thank you.
Could I just take you back to your own affidavit and your bundle at page 68, please? Sorry, give me a moment.
One moment.
So I need to take you to 66.
Okay, I'm there.
It's taking you back to 1811, Regulation 1811, which says that the Financial Secretary shall maintain a list of pre-qualified contractors. The Commissioner heard evidence earlier today, earlier this week from the internal auditor, and the internal audit department conducted an audit of petty contracts between 2007 and 2010. The audit itself was done in 2012, and what that established, or one of the findings that they made, was that as of April 2012, no such list existed in the Ministry of Finance, nor was there a list in any ministry. Do you know if such a list exists in the Ministry of Finance today?
Well, if I may take us back, just to preempt to your statement, I believe. So did you say did I hear you say that the report said that such a list did not exist within
Yes.
the Ministry of Finance or other ministries?
Would you, I'll read out to you what the report actually says, Dr. Glasgow. I think that may be the fair way to do it.
Okay.
It said this, and it's a report, as I've said, that was produced in April 2012, and its title is Petty Contract Administration 2007-2010. And it says, the Public Finance Management Regulations 181 mandates that the Financial Secretary shall maintain a list to be approved by the Minister of pre-qualified contractors for the procurement of services, including construction works. The review has revealed that such a list has not been produced, neither by the Ministry of Finance nor the other ministries. As a result, there is no record of any assessment done to determine the suitability of a contractor to carry out the contracted works. So what I've taken from that is that as of April 2012, a list did not exist. And my question was whether, that's obviously before you joined the unit and became Director of Projects, but are you aware if, firstly, if whether such a list exists today? And if so, when it was first created?
Well, I can say this without fear of contradiction. As I mentioned in my preamble, I started at the Public Works Department in 2004, and I was director in 2007, and I left in 2012. Between 2004 and 2012, the Public Works Department has always maintained a list of contractors. It has always maintained a list of registered. There was a specific form, and we had a list, an overwhelming list of contractors. From time to time, we had to produce this list to the Ministry of Finance. Now, I didn't work at the Ministry of Finance, so I have no idea what the Ministry of Finance would have done with the list. But we, at the Public Works Department, it was a Form C, I know it very well. We maintain a list of government contractors. Again, for this very purpose. So I'm not sure at what level the internal auditors report, if they meant at the Ministry of Communications and Works, which is the parent ministry to Public Works. But the Public Works Department, up to the time I was there, has always maintained a list. And so, as I mentioned too, I'm not sure the financial secretary would always request this list. And so it was a common thing that we produced the list. I remember it very well because it was in an access database, and we always have this list. But be it as it may, that's the internal auditor's report. If you trickle down to today, it's something that we have always tried to do to get a proper list, because this actually speaks to a pre-qualification process. And during the procurement reform that we've been working on since 2014, we've always talked about a contractor's registration and the next C slips me, but system, but it's a system where you actually
classification.
Classification. Thank you so much for that.
I'm going to take you to that next. So
okay.
I'll let you finish and then I'll take you to the page.
Okay, so the contractors registration and classification system. So over the time since I've been at the Ministry of Finance, it's something that we wanted to streamline. And so we had several different iterations of how to do this and to get it right. In recent times, we have actually started to, because we didn't want to preempt the legislation that's coming on stream, because it's a full section on that, on creating this, and this is what you're going to use. So we were aware of this regulation 181, and we always wanted to make sure this works, but we could never get it right. We tested a few different models, but right now, I should say after 2017, we started to build back this list. And right now, as a consequence of the amendment to the regulations in 2020, as a part of that policy, emergency policy, we're mandated to maintain this list. And so we use that as an opportunity to make sure that this list is generated and it's going. So the list is in existence. We have it at my unit. We have done, I think it was 3 or 4 different public notices for contractors to register. The first step in the process is for them to register their companies. And of course, the second step would be a full classification through their qualification, etc.
I will go to that, and I'll go to the document in which it's set out in a bit more detail. But just before we leave the Public Works Department, so your evidence is between 2004 and 2012, the Public Works Department maintained a list. Did it make that list available to other ministries as well as the Ministry of Finance?
As far as I can remember, yes. And we were required to send it to the Ministry of Finance.
And I'm going to capitalize on the fact that you were the director of the Public Works Department by asking you to deal with something else that is mentioned in the audit report.
Are we leaving Regulation 181?
Yes, I think so.
Dr. Latz, can you help me with this again? It's a similar point. In Regulation 181.2, it says that halfway down, an accounting officer may select a suitable contractor for providing services required from the list of pre-qualified contractors if the contract sum doesn't exceed $50,000 with the approval of the financial secretary, or up to $100,000 now, the approval of the minister. Does that apply to works orders, stroke purchase orders as well, or only to petty contracts and major contracts? No, sorry, only petty contracts.
So both works orders and petty contracts.
Great, thank you very much.
It's taking you back, if I may, to the Internal Auditor's Report of April 2012. What's also said is that, and I'll read it out, based on research, the Government of the Virgin Islands, through the Ministry of Communications and Works, has approved a listing of agreed prices by which the Department of Public Works must use in preparing bills of quantities. However, it was not found that consultants are required to use this price listing when preparing bills of quantities. My question to you is, and it's picking your brain as the former director of the Public Works Department, but whilst you were in the Public Works Department, was there a list of agreed prices by which the Department of Public Works operated?
That's correct.
If we go to 104 in your exhibit bundle.
I'm sorry, which page, Mr.
104.
Yes, thank you.
It's the policy on procurement in emergency, disaster, pandemic and catastrophic situations of July 2020. And if we just turn to just give it context in terms of why this policy was developed, Dr. Glasgow, if we go to page 108, you'll see there at the third paragraph down that what's said is that on the 28th of May 2020, the Premier announced phase 2 of the economic response plan to the impact of COVID-19, which included, amongst other packages, a grant in the amount of $40 million from the Social Security Board to fund an economic stimulus program. And it continues that the Premier had outlined the rationale for requesting this grant, expressed his sincere appreciation to the Social Security Board for the approval of the same. The Premier reiterated the Government of the Virgin Islands' commitment to the principles of good governance, accountability, transparency and value for money, and committed that this would be adhered to in the execution of the economic stimulus program. Now this is a Government of the Virgin Islands document. It's obviously looking at procurement in an emergency situation. But if we go to page 113, please. Now that's where it addresses the contractor registration and classification system that you were just mentioning. Do you have that, Dr. Glover?
Did you say 113 or 103?
113, yes.
113. Let me get there. Okay. Yes.
It's under the heading the framework, and it refers to 181 of the regulations, which requires the Financial Secretary to maintain a list of pre-qualified contractors. And then it continues, in keeping with best practice, this list has been referred to as the Contractor Registration and Classification System, CRCS. The CRCS is a critical component of this framework, and therefore it must be brought current. The CRCS will be used for all categories of procurement. Now, firstly, you've spoken of the procurement reform has been an ongoing project, and it appears, if I've understood your evidence correctly, to have been part of your remit as Director of Projects since you took on that role in 2014. Is that right?
Correct.
So this isn't something that has emerged recently. It has been a project that is ongoing for some years.
Correct.
Now, in terms of the contractor registration and classification system, the reference is that the words that use is that it must be brought current. So does that mean that the list that was available, or the list that existed in July 2020, was seen to be out of date?
That's correct, because what we had was a simple list. We did not have, or a semblance. I know, as I mentioned in given evidence a few minutes ago, we went through the various options, iterations of trying to get this list or the qualification component of this list correct. So when this framework was authored, it of course realizes that we just had a list that we've been used from before, and we did have a list, but in terms of classifying the contractors and seeing what their qualifications were, seeing what their successes or the failures on government projects were, those were not recorded. And so, in keeping with best practice, introduction of this CRCS would of course bring any list that we had previously current.
And sorry, Commissioner, did you?
No.
Just keeping with the point of future developments, we see it summarized at the next page, 114, in that you are, or the framework and what the system does is to introduce categories of contractor who will be allowed to work on specific projects, but will have to undertake, as I've understood it, a certain level or reach a certain level of training in order to qualify for that kind of work.
Yes and no. Let's make sure that the statement is correct. So yes, in terms of yes, we want to ensure that they have the particular training, but what we would do as a part of the registration is, of course, we get the information on the type of works contractors do, the experience, etc. And based on an assessment of where they are, we identify what we think their training needs are. And so it's placed within these categories on this process flow as mentioned on page 114. Okay, so wherever gaps there are, we can, because we didn't just want to produce a list. As if you read up in the back on the previous page that we were on I think it was section 2. If you look at section 2, it speaks, or it should speak.
Is that a 108?
108, back to 108. Yeah, I authored this document, so I should know it off my head, right? Part of it was to ensure that that we not only identify contractors. I'm not seeing it on this page, but a part of it is also to ensure that we train contractors to deliver the best service. And so we didn't just want it to make it a list. And even before this, in the Ministry of Finance Projects Unit, we wanted to do more than just have a list of contractors. We want to ensure that we were training contractors to actually be successful. And so by this policy, with small steps, we think we could have gotten them to develop their skills by introducing a training program into this policy.
I think you refer to the training program at 113.
113. Okay, yes. Yeah.
I think I was trying to summarize it too shortly, but you refer there in the third paragraph to the classes that you will have contractors.
Okay.
And the training programs that will be put in place. But is that looking forward to what you intend to do, Dr. Glasgow?
Yes, that's looking forward. Yes. So we have started the process, of course, and just for clarity, any project that will be executed using this policy, yeah, of course, the policy speaks, it has to be approved by the cabinet, but any project that will be executed by this policy, any contractors that will do work or be invited to submit bids or quotations for this on this particular under this policy has to be on the CRCS. So that's a requirement. They have to be registered with the CRCS. So again, we found that this was a perfect opportunity to get section 181 of the regulations in play. And so the system is set up right now. Once a project has been approved by the cabinet to be implemented under the policy, contractors or any vendors, etc., has to be registered on this list. And
is a key difference between what existed before and what this system will introduce is that you will also be able to measure the performance of contractors.
Correct, performance-based, yes.
Whereas what you had before was, as you've described it, it was just a list.
It was a list. It asks for a pre-qualified list. But we found that the pre-qualification part was not being used. And so we tried to develop what that pre-qualification would actually look like.
So just to sort of try and understand in terms of the information that has been available to ministries in past years, between 2004 and 2012, when you were director of the Public Works Department, what you can tell the commissioner is that the Public Works departments had a list which was provided from time to time on request to the Ministry of Finance.
Correct.
And again, forgive me if I've asked you this already, was it also provided to ministries when they sought that information from you?
On occasions, ministries will also ask for that information. So everybody knew that the Public Works was an owner of this list.
And whilst you were at Public Works, did you become aware that ministries also had their own lists of contractors?
Ministry had they had their own list. I'm not sure to what extent they had a list, but there was nothing that said the list produced by Public Works, which was by far the most exhaustive list, was the only list that could have existed. Again, we put together that list to assist the Ministry of Finance, because at that time, petty contracts, most petty contracts, contracts, any kind of contracts, most of that regarding works was funneled through the Public Works Department.
And after 2012 and going through to today, I appreciate you're obviously working on developing a much more sophisticated system. But as far as you're aware, after 2012, did the Public Works Department continue to maintain that list?
I believe they did. I'm not sure up until, I'm not sure if they still do. I cannot speak to that. But I know from time to time, even in my role, once I had moved to the Ministry of Communications and Works at the time, every now and again, I would call to ask for an updated list from what they had, and they could always produce it to me. Like I'd say, I can't speak to how long that continued or if they still, my guess is that they probably still have a list, but I'm not sure to what extent. I have no idea.
And in terms of the ministry itself, what you've told the Commissioner is the ministry has a list. It is just a list. How long has the ministry had that list? Has there been a list since 2014 when you became Director of Projects?
I am unable to say exactly when. I do know, as I was there, I was able to assist with the development of the Ministry of Finance's list or the project units list by even taking the list that I had retained from the Public Works Department as a starting point. Like I said, we had several iterations and levels of sophistication. We actually had a programmer come in to write an access database for us. IT was involved in it, so it was pretty sophisticated. But we maintained just having a list in the Ministry of Finance that we could have assimilated from the various ministries and what we had before.
Thank you. Commissioner, I've reached the end of my questions. Can I conclude firstly by thanking Dr. Glasgow for the time that he's given to the Commission today, and also for his patience, because I think we asked that he be available from 2 o'clock and we started a little later than that. But lastly, but not least, can I also thank him for the way that he's given his evidence to the Commission?
Yes, Dr. Glasgow, thank you very much. It's been very useful to explain to us, to me, how procurement works in practice, which is very, very important. We understand that. So thank you very much for your time.
Thank you very much.
Right.
I think our next scheduled hearing is on Tuesday.
At 9:30, I think.
9:30.
Good. Thank you very much. Thank you again, Dr. Glasgow.
Thank you.